Not uploaded yet, my lord.
Give me the, supply the numbers which have not been uploaded.
On the date 5/1/2024, my name has been wrongly recorded, ma'am.
Correction.
Lordship, one extension of interim order, Lordship.
Extension of when it is expiring.
15th of December.
It has expired.
Expired,
My
but
lord,
extension of filing has already prior to that.
The file the
Yes,
application.
yes, yes.
It will appear.
Lordship.
Let the file. Yes. Next. Yes, Mr. Shah.
I do one matter. The order, my name.
Does not be. আচ্ছা ওটা
my lord,
আজকে সাপ্লিমেন্টারিতে দিয়ে করে দেওয়া যাবে না লিস্টে দিয়ে দিই tomorrow. Yes, Mr.
my lord,
Chatterjee.
may I most humbly, my lord, mention a matter before your lordship, my lord? For
Yes.
some reason, I can't hear your lordship, my lord, but
Uh,
an
শোনা যাচ্ছে
extremely urgent matter, my lord, with respect to an extreme
Yes, Mr. Chatterjee.
urgent matter, my lord, with respect to the medical examinations, my lord, admissions. My lord, there was only a direction. My lord,
What?
can't hear your lordship.
কি হলো শোনা যাচ্ছে না কেন Mr. Chatterjee, they are my
There was a direction, my lord, to find out if there is a vacancy or not.
Lordship, I'm Mr. Chatterjee's junior.
Yes.
It's not in the list.
Yes, Mr. Chatterjee.
Kindly keeps it tomorrow, my lord. It's a life of 6 medical practitioners. 6. My lord,
What?
there are vacancies. We've come to know, my lord, there are vacancies. Keeps it tomorrow. I will take 5 minutes of my lord's time.
Who is
5 minutes. I will be there personally, my lord, before your lordship.
who is opposing you?
My lord, I can't hear your lordship at all.
শোনা যাচ্ছে না কেন
Lordship, it's West Bengal University of Health Service.
Who appears for West Bengal University of Health
Mr.
Service?
Mr. Devakanandan Maiti.
Survey. Have you filed the application?
Yes, Lordship.
কালকে দিয়ে দিন।
Grateful to your lordship, lord.
Full, your Lordship.
Tomorrow in the morning, my lord, if it's possible, my lord.
he can't-
Grateful, Lord.
Lord, I'll ask from my junior what your lordship said. I couldn't hear anything.
Yes, communicate it with as soon as the file comes.
Grateful.
Yes.
Lordships argued plus the extension of the ability in opposition. Only 3 or 4 days we have already shut out the problem. The affirmation was will be on commission.
As read for by Mr. Singhania Learned and yes.
The order was passed on 26th of September 2025. And they were given ample opportunity to file the application. My lord, in the same, and in the meantime, let me complete. In the meantime, what they have done, my lord, they have copied salary of the petitioner.
Lordship kindly
Since
consider
they were not
earlier
paid, my
order,
lord,
Lordship.
I'm keeping it in the next circuit bench. So
File your opposition. 20, your lordship.
within,
Within 20.
28th of
I can start from 22, your
no,
lordship.
but they have to file reply. Today we are on 10th.
10.
So do it by circuit is starting from 22nd.
22nd,
So you do it by 17th.
17.
Yes.
Lordship.
On the pair of Mr. Singhania Learned Advocate for the Union of India. Time to file affidavit in opposition is extended as a last chance till 17th of January 2024. Reply thereto, if any, be filed by 20th. 20th is Saturday, so do it by, I'm saying 22nd, on or before 22nd of January 2024. Pusat, the petitioner shall serve an advance copy of the reply to the learned advocate for the Union of India. List this matter before the next
ask him to release the salary matter because the daughter.
That 22nd is next. Yes, this matter before the next available circuit bench. Yes, next. Yes. Where is Mr. Mukherjee?
But I have got not only 5 minutes to submit before your lordship not on the issue.
Yes, yes.
Both the issues, not your lordship has seen by reference to not the order passed by Justice Sinha, which is at page 110 of the second writ petition, 1725. The issue of the Honorable Court was whether the construction was made on a government land or not.
Page 110.
Starts of Justice Sinha,
Yes, yes.
109, absolutely, 109. In writ petition number 1725, not the second writ petition, item number 4.
Yes, yes. I've got page 110.
And wait, the order starts at 109. But am I
It's breaking. Mr. Mukherjee, your voice is breaking. আমাদের দিক থেকে কোনো প্রবলেম নাকি? আগে শুনতে পাচ্ছেন না বললেন উকিল বাবু।
not I very clearly?
Yes, yes, Mr. Mukherjee.
Problem, page 109,
Yes,
petition was passed, my lord, because of the writ petitioner complaints, the second paragraph,
yes,
petitioner complains that the private respondent herein encroached the PWD land and are making construction therein.
yes,
The scope of complaint in the first writ petition.
yes,
My lord, the BDO was directed, my lord, to inquire. Otherwise, BDO is not an authority under the Panchayat Act, my lord, to inquire.
yes,
Now, my lord, on the scope of the inquiry that was directed, that this was a consequential order, my lord, upon the BDO, my lord, to see whether the construction was legal or that it had encroached, my lord, the government land or not. That your lordship will find, my lord, in the operative portion of the order, at page 112.
yes, I'm at 112.
View of the above, the instant writ petition is disposed of by directing the block development officer, Matigara block, to consider the representation dated such and such, made on behalf of the petitioner by his learned advocate being annexure P such and such, appearing at such and such, strictly in accordance with the relevant rules, guidelines, opportunity of hearing and thereafter. It is made clear that the block development officer shall not be entitled to decide upon the title of the land in dispute. The said officer shall only restrict his decision with regard to the illegal construction being made and make specific finding on the basis of available records as to whether the land is a government land or not. All the parties shall be entitled to rely upon the necessary documents in support of their case. So,
Yes.
but on the of this, Lord, he passed an order which, Lord, says that this is the construction not made on a government land. That is, Lord, the subject matter of, Lord, the item number 3.
Yes,
Now, Lord, on that, Lord, my submission before your lordship, Lord, in the first writ petition that the petitioner has stated, assailing, Lord, the order of the BDO, Lord, the legality of the construction was, Lord, consequential upon a finding whether, Lord, it was raised on a government land or not. If it was not raised on a government land, BDO was not an authority, Lord, to find out the legality of, Lord, a construction. So, Lord, I rest my case so far as, Lord, the first, Lord, the petition is concerned.
yes,
Now, Lord, coming back to, Lord, the question of, Lord, the grant of permission. Lord, before Justice Amrita Sinha, Lord, your lordship will find, Lord, our submission was recorded at page 110. Page 100. Lord, in that say the writ petition your lordship is looking at.
yes, yes, page 110.
Third paragraph. Learned advocate appearing for the private respondent submits.
Yes,
As per convention, the private respondent have made construction in the land in question after obtaining oral permission from the Pradhan of the Gram Panchayat.
Yes.
It's been further submitted that the private respondent are the owners of the plot of land where the construction has been made. Therefore, Lord, as on 24/2/2020, it is submitted, Lord, that the construction is being made on the basis of an oral permission. This is not what that has been recorded. Now kindly come to Lord, our first Lord, the letter that we had given to the Pradhan, Lord, asking him to grant us the permission. But that is that page, Lord. Kindly just bear with me for a moment, Lord. Yes,
Page 138.
138. Yes, Lord, I'm grateful to your Lordship. 130.
Yes.
Lord, this was dated 17/2/2020.
Yes.
Lord, on the basis of this, Lord, this was given prior to the date when Lord, our lawyer made a submission before the court on 24th of February.
Yes.
In the second paragraph, Lord, it is stated that but the permission was not granted by you as I had not kept any provision for toilet in my site plan and application. And thereafter, Lord, there was a Lord, undertaking that he will construct a scientific toilet along with the shaded structure. And that was the Lord, the permission granted by the Pradhan. Now, Lord, here the question arises, Lord, whether the process of application was correct or not.
Yes.
Lord, the process of the application, Lord, if I go by the books, Lord, it was not in the application, that was not in the statute book. If your Lordship has with your Lordship, Lord, the Gram Panchayat administration rules, Lord, yesterday, Lord, the book was handed over by Mr. Vasu, Lord.
Father, are you carrying that? Oh, yes.
Gram Panchayat administration rules.
Where is that? Oh, sorry. Hey, বইটা দিন তোমার বইটা রয়ে গেছে। You should have told that it is there.
Your
I-
Lordship gave it yesterday, Lord, I've seen it. Your Lordship asked Mr. Vasu that I'll retain this book.
Yes, but Gram Panchayat Constitution. Yes, administration rules. Yes.
And Lord, if your Lordship kindly comes to Lord, control of building operation under Chapter 4, that is not Rule 17. But this is the process which is not required to be followed.
Rule 17. Yes.
And Lord, this is an application in Form 4 which is not required to be done.
Yes.
Yesterday, your Lordship was asking me that there must be some exemption in the nature of Rule 3 of the Calcutta Municipal Corporation rules.
Yes.
As your Lordship will find in Rule 19, exemption from permission.
19 speaks about exemption.
Only where I am hit is, Lord, it talks about without brick wall. So the tin shed is not exempted, brick wall is not exempted.
Yes.
But only for this purpose, Lord, I had to apply because it is a tin shaded temporary structure.
Yes.
Now, Lord, if your Lordship kindly sees, Lord, Rule 24 and 27, the manner of processing an application.
Mukherjee, without interrupting you, 19 does not say about pakka or kacha. It says with or without brick wall.
Yes.
So so distinction can be made that without brick wall is a kacha construction according to you. With brick wall is a pakka construction or a permanent construction, whatever it might be. So statute or the rules do not use the expression kacha or pakka. So only with or without brick walls.
It requires a permission. Let us take it that way.
Yes.
Because it says without brick wall.
Yes.
Because the white blood rests on a brick wall or it might rest on a blood or temporary blood or iron structure,
Yes,
or a mud wall, maybe mud wall.
yes.
Rest on a mud.
Consideration is wall is constructed by what material?
Yes, yes, it's brick. If it is brick, then blood, it is not an exempted blood from permission.
Yes,
You have to make an application before the authority. Otherwise, I need not have any necessity of applying before the authority.
yes,
Admit before your lordship, Lord, that the process by which Lord the panchayat had acted may not be in consonance with Lord the statute. But Lord, the permission has nevertheless been granted. Lord, after the permission has been granted, but it cannot be said as of today that the structure is an illegal structure,
yes,
because if during the construction phase, Lord, if the authority found Lord that I am making construction dehoys Lord what that they propose to sanction or have sanctioned, your lordship has seen Lord, I have given them the plan, then they could have Lord taken an action under Lord Rule 27 sub rule 4.
yes. Rule 27, sub rule 4.
But what that they are supposed to do, that they have not, I have shown before your lordship pointed out Lord that Lord, the permission was granted on 26 to 2020.
Yes,
Lord, if permission has been granted Lord, as of 2020, 26th of February, but my learned friend cannot complain that the structure which stands on as of today is an illegal structure.
yes, yes,
Now, today, if your lordship is of opinion that the decision-making process in the sanction is illegal, or it does not follow the statutory principles or the guideline, there is also not a standard operating procedure which I'm not bothering your lordship, because that is an internal blood, a document of the government. I have that standard operating procedure of sanction of a building by a panchayat.
yes. We need not go to that far, Mr. Mukherjee.
And doesn't have any statutory force, and therefore it is only a guideline, administrative guideline.
Yes,
Now, if your lordship is of opinion that the process that the panchayat have taken is the illegal process, then your lordship may direct blood by client blood to apply in accordance with Rule 90, and blood the statute mandates that it has to be blood, a decision has to be taken within a period of 30 days. If a decision is not taken within 30 days, there is a deemed sanction provision.
no, deemed sanction is, Mr. Mukherjee, subject to correction. You have to prefer an appeal before the authority. I think that is the provision.
Against
There is an appeal provision because Municipal Act also contains an appeal provision. I think there is also a similar provision in the Panchayat Act also. Deemed sanction is not automatic.
deemed sanction is blood Rule 30, and appeal is, as your lordship said, blood in 38, Rule 38.
So there is a provision of appeal. So, so it's not automatic that within that time, if it is not granted deemed sanction, you have to prefer an appeal. So if no appeal, no decision, then deemed sanction.
Blood, kindly have a look at blood Rule 30, blood for once. Rule
Please.
30.
Yes.
It says that as the case may be is not communicated by the Gram Panchayat within the prescribed time limit, it shall be presumed that the Gram Panchayat has accorded such permission, and it shall be lawful for the applicant to erect any structure or building conforming to the building plan and the site plan furnished by him along with the.
Yes. So Mr. Mukherjee, it's not automatic. It says you have to give an intimation thereafter. It's not automatic. So prior to making construction, you have to give an intimation. Even in the case of deemed sanction, you cannot raise saying that it has been granted. You have to intimate. That is Rule 30, last part. And the applicant shall, after an intimation to the Gram Panchayat, can erect an structure or building. So it's not that after expiry, you don't have to do anything, raise construction. You have some obligations under the statute to perform before raising construction.
No dispute on that, but the first intimation that I had granted is at page 140, that is on 10th of January.
Mr. Mukherjee, we need not go that far because here is a case where permission rightly or wrongly has been granted in your favor. So let us not go to the deemed sanction part. So whether the permission is there or not there, that will be considered. We need not go into deemed sanction part.
Going back by the dates, the first was an application which was received by the Gram Panchayat on 10th of January.
Yes.
Honorable Court on 24th, my lord, there was a submission that on the basis of a oral permission, we started construction. On 26th, my lord, a permission was granted, which is on record before your lordship, along with the sanction plan. The structure is a temporary structure, tin shaded, that is admitted.
Yes.
Now, my lord, the only thing, my lord, that the writ petitioner had complained was, my lord, his prayer was at page 146.
In which writ petition?
The second writ petition. I am referring everything in the second writ petition, 170.
Yes.
Paragraph 13, my lord, this is their prayer at page 146, is not for
Yes.
calling of construction of Kacha structure. So the permission is allegedly granted to said Naresh Chandra Burman for construction of Kacha structure is required to be recalled at once without lapse of any further.
Yes. Yes.
So, my lord, this was not the scope of the writ petition.
Yes.
Deliberation on other issues, your lordship is now posted with the facts and not the legal position as of today. If your lordship is of opinion that the process of sanction or permission was illegal, your lordship may kindly allow my client to take a corrective statement.
Yes.
I'll address your lordship on the judgment that Mr. Basu had cited yesterday. That judgment, my lord, in my respectful submission, my lord, that is on the question of, my lord, paragraph, my lord, if your lordship kindly comes to, my lord, the judgment at paragraph 13. I'm just referring the CHN version of.
Give me a minute, Mr. Mukherjee. Yes, I've got that.
The paragraph in CHN is, my lord, paragraph 13. After dealing with, my lord, the judgment cited.
Yes.
Having regard to the aforesaid legal position as in the instant case, Gram Panchayat has not communicated any resolution refusing to accord permission. We are of the view that the impugned letter of Pradhan dated 7 June 2010 has no legal value, and in the eye of law, it would be deemed that the Gram Panchayat has not considered the application as yet. Under Rule 30, there is a dealing clause that in the event of non-taking any action within 30 days from the date of receipt of application, it will be lawful on behalf of the concerned applicant to construct the building. But we are not inclined to pass a declaration to that effect in terms of Rule 30 for the reason that the Panchayat authority practically has misdirected themselves to interpret the particular provision of the state rule as referred above. And as such, Pradhan, without considering law, was overzealous on the issue and took decision to invite the writ petitioner to meet him. Thereafter, Rule 30 was read as under.
Yes.
Judgment which has been cited
given a copy because paragraph, the next paragraph 30, rule 30 is incomplete in your copy. Do you have another copy? Because this is not a complete. Kindly check up after paragraph 13. But it's not complete. Yes, Mr. Mukherjee, you can make your submissions because it's not a complete copy as I find. Yes, what you have,
Submission does not augment below the proposition that the petitioner says.
yes,
About below the Pradhan's decision, my lord, concerning below the non-grant of permission, the consequence of Rule 30 that has been my lord, enumerated by the division.
according to you, this was a case of deemed sanction. You are not concerned with that since a permission has been granted in your case.
I'm great.
Yes.
Fine. But
So-
I guess- but I have-
Mr. Mukherjee, anything more?
but I guess not.
All right. What reply? All right. I'm keeping at 2 p.m. I will be passing orders. If Mr. Basu wants to submit anything, he can make his submissions. I will be dictating the order at 2 p.m. Mr. Mukherjee, at 2 p.m. I will be dictating the order. You can ask your junior to remain present. I'll be dictating the order at 2 p.m. Because Mr. Mitsuka says Mr. Basu may make some submissions
You have to give opportunity to Mr. Basu, my lord.
in reply because you have concluded today. All right. 2 p.m. রেখে দিন. Ask Mr. Basu to join at 2 p.m. Yes.
Number 5.
Yes. What is this for orders? Similar matter.
I was able to, in fact, the court officer was kind enough to hand over a copy to me.
Yes. After you left, the court officer said it has been uploaded.
No, it is not there, sir.
But it has been uploaded from the server.
From our end, it is still not there.
তো কি হচ্ছে তাহলে? কেন? না, তাহলে তো একটা কিছু গন্ডগোল হচ্ছে এটা, তাহলে তো Yes, Mr. Shah, this is the problem from our end because Mr. Mishra yesterday said it was not in the server. My officer has downloaded that
It's still not in the server.
and he is saying, and it has been also downloaded from the server and he is saying still not in the server.
The list I have given you, my lord, entire list has been checked in the morning.
Yes, but it has been downloaded from the server yesterday.
No, no, because my lordship has the internet connection to my lordship has the access fee, but he from outside, it's not a
Internal server, it is there, but it
it is on the internet
আর
server.
তাহলে ওটাকে কিন্তু কিছু করতে হবে তো, তাহলে কি ওটা I'm told that there is some problem with that. That is why. তো ওটা দেখে নিন যে মানে যাতে হয়.
But I've done what I have to do a little bit of notes, state wise correction so that it is convenient for the officer.
Who is appearing for the state? Have you given a copy of this to him?
So I was there when the order was passed, I know that.
So I'm passing the similar order. এই সেম অর্ডার এইটা যেটা আছে, ঠিক আছে?
Appearance of the state council will change.
ইয়েস, শুধু অ্যাপিয়ারেন্স স্টেট কাউন্সিলের অ্যাপিয়ারেন্সটা চেঞ্জ হবে আর এই সেম অর্ডার যেখানে কারেকশন করে দেওয়া আছে, ঠিক আছে?
Thank you.
Yes, next.
Item number 6.
I'm going to condition order on the equal relaxation of the condition.
Yes, who is for the state? Pass over, next. If possible, before that, we'll take. Yes, next.
7 minute time for. Time for the, you know.
Yes, Yes, what do you say? Pass over. Pass over next. Take back the affidavit, file at the time of call. Yes. Prayer of the learned advocate for the petition, list this matter before the next available circuit bench. Next. As paid for by the learned advocate for the petitioner, list this matter before the next circuit bench. What is it? It what has been done?
Next, item number 10.
Straight, they said next circuit. Yes. You are led by? Where is she? Yes, who is appearing for the state, Mr. Yes. Any other private? Yes.
There is a function for appealing now.
North Bengal University, who is appearing? You are appearing for North Bengal University. Yes, sir. Another, I think, yesterday or day before yesterday, another matter, North Bengal University, which matter I forget. You are regularly appearing for North Bengal.
I'm only appearing for that. But I believe what has happened or now the PC is there. There is a bit of correspondence issue figure. We don't have to agree. But
This matter.
no, it is not.
All right.
It's not.
Yes, what is this matter?
They're challenging the report of the committee, internal committee.
Yes.
The
Where is the petitioner? All right, all right. Call her.
function for appeal.
What is their challenge?
But I'll just read the manual. But it's a premature state. What has happened now? There is a complaint of sexual harassment of a PhD student.
Yes.
If provisional matter is not, this will not be guided by this act, this will be guided by this.
Yes, my lord, I am appearing for the petitioner, lordship.
Yes.
Yes, we are appearing for the petition.
Yes. All right. Let the petitioner submit. Yes.
Lord, I was appearing in this matter for the petitioner. Lord, this matter, Lord, needs to be heard after exchange of affidavits. But Lord, I am seeking for protection so that no coercive step can be taken, because I have filed a detailed representation before the concerned authority, which needs to be considered. And if your lordship sees the representation, representation. But if your lordship kindly sees the representation which I submitted,
Page.
Page 26.
Lord, there has been gross violation of the principles of justice in conducting the ICC proceeding.
Page 26.
Lord, kindly have a look to page 26, annexure P7. Lord, that is my detailed representation. Lord, and I have pointed out, Lord, where there has been violation.
So you
Therefore, Lord,
consider.
at this. Yes, Lord.
No. what do you want? What is your prayer now? To recall the suspension order
Lord,
and
my prayer is, Lord, let the recommendation, by the ICC be stayed until the final hearing of the writ petition, Lord, subject to your Lordship's kind consideration.
challenge of the ICC report? What is the ground of your challenge?
Yes.
To the ICC report?
Yes, because the grounds which I have stated in my representation,
Where is
those are the grounds, not we possibly, Lord, I have been able to show the
Mr. Rai? Where is the
possibly, Lord, I have been able to show the violation.
no? Where is the ICC
Yes,
report? You have not annexed that.
ICC report.
The ICC report.
Lord, I am just giving your Lordship the page. ICC report is page. Yes, Lord. Lord,
State said that since this is an interim BC,
ICC report, page 10. ICC report.
Communication of the register is page 5.
Lord, huh?
17th.
Lord, kindly text, Lord, kindly have a look to page 22.
Out of the petitioners are there. Then there is a provision of appeal under this.
Moon petition.
Yes. So at this stage, there is no occasion to take any court against the petitioner.
Taken under number 10(6) of the
Yes, Lord.
In
6.
Lord, I am seeking, Lord, I am seeking from your Lordship the protection with regard to holding any disciplinary proceeding or initiating any criminal proceeding against me for the time being until the writ petition is heard out.
Yes, sir.
Finally, because, Lord, I have been able to show the violation
which act?
committed by the
North Bengal.
Internal Complaints Committee, Lord, in conducting the proceeding.
Mr. Rai, give me a minute. Let me.
There be no coercive step. Lord, till the writ petition is heard, let there be no coercive step against me, Lord. And Lord, I am another point, Lord, I am urging before your Lordship, Lord, I am under suspension, and Lord, there has been no initiation of departmental proceeding as on date. Therefore, Lord, the suspension should be removed.
No, suspension has been made only. Only suspension. So there cannot be, Mr. Rai, there cannot be a stay of the suspension order. You have not been, no disciplinary proceeding has been initiated because unless the ICC report is placed, recommendation whether to proceed. Yes. So no, that has yet been taken. No disciplinary proceeding has yet been or has yet been initiated. Only suspension order has been passed. So there is no scope of any. চলে গেল। What is the coercive steps they have paid? What is the interim order they have paid for?
One is saying suspension order but the first
Suspension order is under challenge.
no suspension order is under challenge here.
No, it has, yes, in the writ petition it has been challenged. And where is that prayer? Prayer D to cancel. And where is the interim order paid for?
H. There's H. I only just refer to one.
Yes. After hearing the learned advocates for the parties, this court is of the considered view that this writ petition, that the issues raised in the writ petition can be decided only after exchange of affidavits. First up, let affidavit in opposition be filed within.
The 17th is proposed.
Within 3 weeks from date, semicolon, reply thereto if any be filed within a week thereafter. List this matter before the next available circuit bench after expiry of the period fixed for exchange of affidavits. Paragraph. The writ petitioner has paid for quashing the suspension order dated November 10, 2023. Full stop. The learned advocate appearing for the petitioner submits that submits that such suspension order should be stayed till the disposal of the writ petition. Full stop. Such prayer cannot be allowed as the same would amount to granting final relief to the petitioner at the interim stage, which is not permissible. The prayer for interim order stands refused. Yes, next. Take back your respective copies, book and the copies. Yes. So, Bhattacharya, is it so urgent? Because
Very urgent. I will take only 1 minute of it.
who is your other side?
Both are there. Lordship, this is a covered matter. This judgment can be that day.
You have got a server copy?
Yes. Thanks to the court officer, I have received. That-
No, he has supplied you the copy or you have downloaded?
No, he has supplied me.
So, but you are still not getting in the server. Have you checked up that it is?
Just now I have checked it up. It is not there, but it will appear in some time.
We took it to Dekshin in because they have to.
Order, I can make the necessary corrections of date and the name of the party council. And this order will suffice. Here also what has happened. The claim of income tax has been.
Yes, who is appearing? You are appearing. What do you say? Mr. Agarwal is.
My lord, I am appearing.
Oh, you are appearing. Yes, what do you say to this? Have you?
Gone through the judgment.
It is only this, it is only.
He has to go through the judgment. You are relying upon a similar order. Let her go through that judgment. I am keeping at 1. You go through this judgment. Do you have an extra copy?
I will make a Xerox. I've just got it. Give me a copy also. I am representing the case. Give me a copy also so that I can also start voting.
Mr. Bonik, you appeared in that matter. She can say yes, copy, because you appeared in that matter. Mr. Agarwal is not a.
Mr. Bonik's chamber is surely going to flood with. He is getting way more copies than he should get.
All right. Give them copies. Bring a copy for the court. Yes.
I'm great. At 1 o'clock.
1 o'clock. Yes.
Well.
Next circuit, my lord, because the order is not being uploaded on the representation. So that,
On the representation.
yes, representation means the GST matter because they are wanted to consider their representation before the chief secretary. So it is being joint secretary.
The learned advocate for the state pays for an accommodation to submit this matter before the next available circuit
Not
bench.
accommodation due to the not uploading of that judgment.
As for an accommodation on some ground.
Yes.
As for an accommodation,
Otherwise, the state will say that why you have taken the accommodation.
explain it to your client. Yes, next.
Lord, item 13, I beg to appear on behalf of the private respondent. Copy was upon us yesterday after 3 p.m.
Yes, Mr.
My lord, I am appearing on behalf of respondent number 7, my lord.
Respondent 6 and 7.
Yes. What is this matter?
Illegal without the sanction.
Yes, who is the chat?
Lordship, I am respondent number 7.
7 is
Private respondent.
My lord, item number 6 I am appearing, my lord.
yes.
My lord, in paragraph number 16, it is specifically stated civil suit is pending between the parties, my lord. Despite of the pending of the civil suit, they have filed this instant writ petition, my lord. Kindly paragraph 16.
What is the scope of Mr. Das? Is this called matter of the civil?
No.
My lord, this issue is still pending, my lord. Interim injunction is refused by the court. Application under order is pending. Next date is
Also,
No copy of plane.
This is not regarding. Procure the from the local. That is not responsible. 7 Milord. And is it later? Respect. Page number 5 Milord. Respond number 6.
so do you have a copy?
No, I don't have me. That
Civil suit about. What is the civil?
my lord, similar issue has been raised in suit. My lord, the petitioner states that for the chain of event above. Yes, that was the private response. The civil number 2 and title suit number 5 of 2020, which is pending before the land. For my instructions, the order has been refused and application under order 77 has been filed. The state is fixed on 31st of January.
Scope of
Lordship, civil, this petitioner, actual relief, recovery against this private respondent.
not recovery of position.
The declaration with recovery person cannot lie.
No. Not there. My son before regarding the house to construct that didn't permission concern or threat panchayat Milord. And the panchayat that is restrict Milord paid by way Milord.
Ashwin. The petitioner alleges that the private respondent is carrying on illegal construction on where what is this plot?
It is yet to be demarcated, Milord.
What is the plot number? Otherwise, a vague order cannot be passed.
Plot number.
Where do I find that? Yes, in plot numbers, in ILAT plot numbers 50 and 51.
Where it is? Okay. Report.
What is the Moja?
Moja is Moja.
Kudung Khasma.
Moja Pudung Khasmahal under police station Kalimpong in the district of Darjeeling.
Kalimpong district.
Separate district.
Separate district
Yeah.
in the district of Kalimpong. Yes, district of Kalimpong. Full stop. The petitioner submitted a notice through his learned advocate dated 30th of December 2023 requesting the respondent authority to take steps against the unauthorized construction which is allegedly carried on. No, which is carried on by the private respondent. Full stop. Mr. Das, are you carrying on construction or not?
Lord, I have to take instructions, my lord.
My lord,
On a query as to the private respondent carrying on, comma, Mr. Das, that he is instructions from his client. Full stop. It appears from the record that the Pradhan of the
Pudung Gram Panchayat.
Pudung Gram Panchayat, being the fourth respondent, issued a notice dated November 13, 2023, directing the private respondent to stop illegal and unauthorized construction on the said plot. Full stop. Since an allegation of illegal and unauthorized তার আগে লিখুন, it further appears from the said notice that during joint verification it was found that the house was constructed in the disputed land. Without any permission or approval of plan by the concerned Gram Panchayat. Full stop, paragraph. Since an allegation of unauthorized construction has been made by the petitioner before the Pradhan of the concerned Gram Panchayat, and the Panchayat authority upon physical verification of the spot has arrived at a finding, has observed that such construction was made without any permission or approval from the concerned Gram Panchayat, comma, this court is of the considered view that the Panchayat authority should take a decision on the complaint lodged by the petitioner, wide the letter dated December 30, 2023. Should decide on the complaint lodged by in accordance with law. So stop. WPA number such and such is disposed of by directing the Pudung Gram Panchayat to take to initiate in terms of section 26 of the West Bengal Act 1973 কি বললাম should is directed to
initiate.
a proceeding and to conclude the same as expeditiously as possible, but positively within a period of 6 weeks from the date of receipt of a server copy of this footstep. Should initiate and conclude the proceedings in accordance with this. কি ওটা কি বলেছে? না 23(6) বলেছি না? আচ্ছা ঠিক আছে, ডিরেকশন পার্টটাতে বলুন কি বলছে? ডিসপোজ অফ
By directing,
হ্যাঁ
company to initiate a proceeding and conclude the same.
হ্যাঁ
In terms of section 23.
হ্যাঁ বলে দেওয়া আছে তো হ্যাঁ।
The West Bengal Constitution Act and the Constitution as soon as possible, but positive.
And to conclude the same in accordance with the said provision. In accordance with ঠিক আছে?
Milord, kindly records that it is pending, Milord, between parties.
আচ্ছা আচ্ছা একটা প্যারাগ্রাফ ঢুকিয়ে দিন যে
And there is no injunction passed in the same.
Mr. Das, learned advocate, appearing for the respondent number 6 and 7 submits.
There is no response.
Five and six.
Respondent numbers 5 and 6 submits that a civil suit pending between the petitioner and the private respondents in title suit.
5 of 2020.
In the paragraph, it has been stated, I think. Which paragraph? Suit being of 2020 is pending before the Learned Civil Division, Kalimpong, and the writ court and the writ is pending. Title suit being number such and such is pending between the parties, and therefore the writ court should not entertain this writ petition. Full stop. It does not appear. Now, the learned advocate appearing for the private respondent. Now, the Panchayat authority Panchayat cartoon. Section 23 of the West Bengal Panchayat Act deals with control of building operations within the Section 23 of the West Bengal Panchayat Act 1973 deals with control of building operations within the limits of within the jurisdiction of a Gram Panchayat. Full stop. To control the building operations within full stop. Since a complaint of illegal and unauthorized construction has been made before the Gram Panchayat, and the Panchayat authority, upon physical verification of the plot in question, has observed that construction has been made on the plot in question without obtaining permission and approval of the Gram Panchayat, this court is of the considered view that pendency of a civil suit between the private authorities, between the private parties cannot be a ground for the Panchayat authorities to shut its eyes over an complaint of unauthorized and illegal construction within its jurisdiction. Thank you, Mr. Das, for pointing out this.
Thank you.
Yes, next. এটা না
please.
ওই লাস্ট প্যারাগ্রাফের আগে ঢুকিয়ে দেবেন এই প্যারাগ্রাফটা লাস্ট প্যারাগ্রাফের আগে ঢুকিয়ে দেবেন
I will go before the tribunal, my lord. Lordship will kindly stay the impugned order. I will go before the tribunal. My lord, in this case, just yesterday at night PM, I have received the copy of writ.
what copy this
This petition before the tribunal, my lord. My lord, going kindly grant me some time so that I can take instruction from the security department. No,
Take
in that case you can withdraw. If you, how can I withdraw? If departmental proceeding,
Mr. Bonik, learned advocate, appearing for the CG.
kindly tomorrow, kindly, my lord, tomorrow, please.
Tomorrow.
My lord, only one line, 22nd is the next 30.
You have seen
I have to go through,
many orders are not being uploaded into server. This is
I have to go through
it's not possible for them.
but I will go before the tribunal. 120 pages. I will go before the tribunal only. The application order needs to be stayed only.
You have opportunity. I'm pressing it. You will rely upon this judgment in the next circuit. As Mr. Bonik, learned advocate, appearing for the CGST.
CGST.
For the CGST respondent. For the respondent.
All the respondents.
For the respondents.
State is also there. I am representing 1, 2, 4 and 6.
For the CGST authority, for the CGST authority submits that he is yet to receive instructions.
Yes.
Full stop. Mr. Bhattacharya, learned advocate for the petitioner, submits that the issue involved in this writ petition is a covered issue. Full stop. Since the
Should not say a covered issue, my lord, because in the
issue has not been decided.
issue involved in the
Mr. Bhattacharya, learned advocate, appearing for the petitioner, seeks to rely upon a decision passed by this court under similar circumstances. Full stop. Since an accommodation has been prayed for, list this matter before the next available circuit bench.
my lord, affidavit of service might be kept.
Every service in court today is taken on record. Mr. Agarwal, learned advocate, appears for the state. Yes, next.
My lord, next minute, item 50, I am for the petitioner, my lord. Item 50.
Yes.
But this is the matter of mutual transfer of primary teacher. My lord, it only decided, only representation to be considered by the board. That is being respondent number 3. I mean, covered by a division bench judgment. Mr. Banerjee, please rely the decision of Rimpa De.
Where is the representation?
My lord, representation, my representation, offline represent page 21. Page 21 and online representation started from page 17, only page 21 to be considered. Page 21 to be considered, below. By the respondent number 3. And Milord, I am relied by a decision of Rimpa De, MAT 1419 of 2023, where offline application is permitted.
6 weeks from the date of receipt of a server copy of this order.
I'm grateful, my lord.
This
I'm
was
grateful.
next.
My lord, next, my lord, this is a matter of, I am for the petitioner, my lord, this is a matter of re-recommendation. My lord, I have been recommended to transfer of to the transferring school, but I went to the school and there is no vacancy. Well, kindly see page number 19 of my application. There is a recommendation by the SSC. Page number 19 of my application.
Yes.
There is, I have been recommended to Batanpur Junior High School, Ratanpur Junior High School to Ranaghat Bharati High School. I have been recommended on 6th, and then next date, my lord, I went to join that school, page number 22. That school is no vacancy. So, my lord, I have made a re-recommendation. My lord, civil judgment is there by coordinate bench. That judgment, page 27. Observation, clear observation. There is no fault of the candidate, it's the authority fault, so authority should consider.
Who is the
School service for an I'm for the state.
you are for the state? Where is Mr. Ghosh? Yes. Where could not be seen because of these files. Because what do you say? You consider this in terms of the, in terms of consider.
My lord, only one point, my lord, if there is no available vacancy, they should accommodate the vacancy. It is relied in page number 27, my lord, just see. My lord, I have any
to consider your representation in the light of the decision of the coordinate.
Lordship, obliged.
The petitioner pressed on re-recommendation to be made by the infant authority of the Bengal Central School Service Commission. First up, the petitioner claims that his prayer for transfer was allowed schools by the Central School Service Commission by memo 6th of July 2022 by recommending petitioner to Ranaghat Bharati High School at Ranaghat. So the petitioner states that when he went to join at the said transferred school, the petitioner was informed that there is no such vacancy in the said school. So in view thereof, this prompted petitioner submit an application for re-recommendation. To stop.
Yes.
Honored advocate for the petitioner places reliance upon an order dated 7th of December 2023 in WPA 9347 of 2023 in the case of Nobun Mukherjee, West Bengal and others, wherein the coordinate bench directed places reliance his attention for re-recommendation. Paragraph. Mr. Ghosh, learned advocate representing the West Bengal Central School Service Commission, in his usual fairness, submits that the prayer of the petitioner may be directed to be considered in the light of the decision in the case of Nabonita Mukherjee Supra. In view of WPA number 83 of 2024 is disposed of by directing whom?
Respondent number three.
By directing the
Respondent number
secretary.
three.
Three is chairman.
The chairman can also.
Chairman is the authority. Also.
Chairman is the, by directing the chairman West Bengal
yes.
Central Commission being the third respondent to consider the prayer of the petitioner for recommendation to consider the representation of the petitioner dated. What is the date?
No, my lord, date is not available. This is a web page, page number 23 of the application. Page 23 of my REIT application.
No date is available.
My lord, no date web page. My lord, next, my lord, in the month of July 2022, I have made it. In the month of July 2022.
July
It is success.
yes. Representation dated July 2022. July 2022.
Yes. My lord, my represent July 2022.
Well, to consider the representation of the petitioner for re-recommendation.
Yes.
In the light of the decision of the coordinate bench in Nabanita Mukherjee within brackets Supra, and to take steps what's up? The district inspector of schools within bracket AC is directed to forward a suitable vacancy to district inspector of school AC where?
Nodia.
Nodia.
Yes. Ranaghat, Nodia. AC Nodia. I am seeking transfer to Ranaghat. My actual school is Jalpaiguri. So it is under the purview of this jurisdiction.
কি বললাম এসি নদিয়া to forward a suitable vacancy the commission fortnight from the receipt of a server copy of this order. Full stop. Upon receipt of such vacancy, the secretary,
the chairman, subject to the chairman.
Then Mr. Ghosh, only there is no necessity of consideration, because in that judgment, have you gone through that judgment?
Yes.
There, since once it has been recommended, recommendation is a matter of course, only a suitable vacancy, you have to issue that.
Yes.
So there is no necessity.
In accordance with the judgment, let the DI forward the available vacancies.
Yes, so
within a fortnight.
I think I have to modify the earlier part, because I have said to take a decision that is not necessary.
Not necessary.
So the DI is to forward and you have to.
Yes.
চেঞ্জ করুন তো এটাকে হ্যাঁ ওটাকে একটু চেঞ্জ করুন ওইখানটা চেঞ্জ করে তার আগে কি বললেন বলুন what is the submission, madam, for the state? You have some role to play. Yeah. Have you seen page 28? Yes, what is your submission on that? You ask the DI to forward.
Forward the vacancies.
হয়ে গেছে The coordinate bench in Abonita Mukherjee Supra observed that one has found petitioner being eligible to be transferred on recommendation, and recommendation letter has been issued. But in view of recommending the petitioner to a school where the petitioner would not join, not for the fault attributable to the petitioner, it is the duty of the commission to re-recommend the name of the petitioner to some other school in the same district. Full stop. The said decision squarely applies to the fact of this case, as the prayer of the petitioner for to be transferred, as the commission issued a recommendation letter to us, has issued a recommendation letter recommending the petitioner transferred to a school where the petitioner could not join, not for his or not for his fault. Paragraph WPA number such and such is disposed of by passing the following direction. Number one, by the District Inspector of Schools, AC, Nodia.
Well, he is not a party respondent. I shall add.
Ekdom upor, as paid for by the learned advocate for the petitioner, as paid for by the learned advocate for the petitioner, leave is granted to the petitioner to amend the cause title by impleading the District Inspector of Schools, AC, Nudia, a party respondent. The state is represented by a advocate, there is no necessity to serve copy of this writ petition upon the added respondent. Full stop. However, the petitioner should be obliged to serve a copy of the amended copy of the writ petition upon the learned advocates representing the parties.
I'm extremely grateful.
One, by age, District Inspector of Schools, AC Nodia, being the added respondent, is directed to forward a suitable to the commission within 2 weeks from the date of receipt of a server copy. 2 weeks, 3 weeks, within a period of 3 weeks from the date of receipt of a server copy of this order. Stop. Upon of such vacancy, this chairman, School Service Commission, being the third respondent, shall issue a recommendation letter for transfer of the petitioner within a 2 weeks, and the board in its turn shall issue order of transfer within a period of 2 weeks thereafter. Needless to mention that the petitioner shall join the post in terms of the transfer order to be passed by the board.
I'm extremely grateful. I'm extremely grateful. Extremely grateful.
My lords, this is my petition. Against the appeal order, my lords. This is a GST case. Facts in a nutshell, I'll tell you, my lords.
Next second, next second.
My lords,
List this matter before the next available circuit bench. Next. Not this week, next.
19, my lords. This is a GST case, small issue, my lords.
All issues are small. Next circuit bench. List this matter before the next circuit bench. Yes, next.
20 GST matter.
Next circuit bench. Tender. Yes.
My lord, I appear for the private respondents.
Yes, yes.
My lord, before my learned friend starts, I have
Preliminary objection.
yes on maintainability in respect with territorial jurisdiction of your lordship as well as
Not within the circuit bench.
no what has been I am based in Murshidabad. All the respondents are in Murshidabad.
Work order was given for Siliguri.
Project, where is the project?
It is in Siliguri, but very good.
Part of cause of action.
Thank you,
Yes.
lordship. And also that I am not amenable to writ jurisdiction.
I satisfy you with that.
Yes.
In this writ petition, I am challenging the work order which has been purportedly given to the private respondent number 4 by respondent.
Work order has been issued.
Yes.
No scope to pass any interim order. File affidavits, maintainability kept open. Since the work has been started.
Work order has been issued.
Work order has been issued. And have you included the party who has been issued? Who is appearing for that?
For I don't know. And their tenure has been terminated, my lord.
All right, so he is challenging the work order. What is the nature of the what is the nature of the work?
Nature of the work, packaging of milk product.
Packaging of milk product. Where is the work order? Have you annexed that?
Yes.
Work order, no.
The tender show me for the
At page 25, A. 25. 25. Page 25 it starts, madam.
for empanelment of dairy plants for packaging.
Yes, madam.
Ashwin, the petitioner has challenged the tender process which was initiated by the which respondent?
1 and 2.
Which was initiated by the respondent numbers 1 and 2. So stop. The learned advocate representing the respondent numbers 1 and 2 raises an objection as to the maintainability of this writ petition on the ground of
That I am not amenable to writ jurisdiction.
on the ground that editor are giving you raise all points since affidavits have been filed. Killer?
On the ground that.
On the ground that the circuit bench at Jalpaiguri lacks territorial jurisdiction, and also that the respondent numbers 1 and 2 is not amenable to the writ jurisdiction. First up, it is not in dispute that the work order has been issued. First up, upon going through the expression of interest, this court finds that the same was for empanelment of dairy plants located in Siliguri for packaging of milk per day and hiring of crates. First up, in view thereof, this court is of the considered view that there is no scope to pass any interim order
Great.
at this stage, since the same relates to packaging of milk. Full stop. Affidavits are to be exchanged in this matter. That affidavit in opposition, কি বললাম, the prayer for, there is no scope to pass an interim order বলে দিয়েছি. Full stop. Let affidavit in opposition be filed within, yes, how soon?
2 weeks. 1 week I can.
You can file within, so that I can fix it in the next step. 1 week from date, reply thereto if any be filed. 1 week takes us to 17.
Yes, my lord.
So you can do it by 19. Reply thereto if any, ওটা 17 করে দিন, 1 week না করে। Affidavit in opposition be filed on or before January 17, 2024.
My lord.
Semicolon, reply thereto if any be filed on or before January 22, 2024. List this matter before the next available circuit bench.
Grateful, my lord.
Next.
22.
Lordship, in item number 22, I am for the petitioner.
Yes.
Lordship, the petitioner was is a retired teacher who worked in a government sponsored school. And after his superannuation, Lordship, he has been appointed as a guest teacher of a government school, Lordship.
Deficit amount, you are claiming deficit amount.
Yes, but
What is the representation?
at page number 19, my lord.
19.
Because they has not followed the memorandum issued by the Chief Secretary, Government of West Bengal.
Yes, so yes, to take a decision on this, the petitioner alleges that the the petitioner states that he was appointed as a guest teacher in life science at a government model school, Fancy Deva, PHANSIDEWA, Darjeeling, on 4th of February 2020 and worked in the said school on 31st of January 2023. Stop. The grievance of the petitioner is that the respondent authority has not paid the benefits to the petitioners in terms of the memorandum number 6472-F within bracket P dated 2nd of December 2019. That is your allegation.
Lordship.
Stop. The petitioner.
Another thing to be added, Lordship. Other teachers are getting the benefit, but I am not.
He further, the petitioner states that. Right? States that. Full stop. Full stop. The learned advocate appearing for the petitioner submits that though the other similarly situated teachers have got benefit in terms of the memorandum dated 2nd December 2019, but the petitioner is being discriminated against. Full stop. He further submits that the petitioner has submitted a representation dated 4th of December 2023, which is still pending. Full stop. In view thereof, WPA number such and such is disposed of. Who will consider? Commissioner of School
Education, Lordship.
Disposed of by directing the Commissioner of School Education, being the second respondent, to consider the representation of the petitioner dated December 4, 2023, and to dispose of the same by passing a reasoned order upon giving an opportunity of hearing to the petitioner or his authorized representative and communicate the same to the petitioner immediately thereafter. Full stop. The entire exercise shall be completed within a period of 6 weeks.
Lordship,
From-
can you make it 3 weeks or within a month, Lordship?
Sir, you have submitted a representation on 4th of December 2023
And 1 month.
and you have approached.
After
today.
expiry of 1 month, Lordship.
That is why consciously, in other cases, I am passing 4 weeks. In this case, I have passed 6 weeks consciously.
Lordship, kindly.
Give some time to the authorities to consider 6 weeks from the date of receipt of a server copy of this order. Full stop. In the event, the decision of the authority is in favor of the petitioner, comma, such authority shall take steps to release, shall take all consequential steps thereafter in accordance with law.
Grateful, Lord.
If he is entitled to take further steps. Next. This you are getting as a benefit since it's
Lordship.
6 years. Yes. Next.
Richi.
Well, 20.
23.
23, yes.
My lord, next circuit, my lord. Only new matters.
What is this matter?
No, yes, yesterday only we received it.
My lord, kindly consider this aspect. It's a case of seizure under GST Act, my lord. My lord, I would 23.
23. So we have not the brief.
My lord, the thing is-
Just now received.
My
The learned advocate, Mr. Agarwal.
My lord, one prayer before lordship, my lord. In this case, my humble prayer before lordship, let the matter be admitted. Some points of law has been raised in this application, my lord.
Matter may be admitted.
Yes, so lordship.
But you are not asking for any interim order.
No, my lord. Penalty has been paid, everything has been paid, my lord. After
From admitting this, you file your affidavits, let it be decided.
Yes.
Yes, lordship.
The learned advocate appearing for the petitioner submits
My lord.
that there is no scope to pass any interim order in this writ petition.
My lord.
Full stop. Mr. Agarwal, learned advocate for the state, prays for a direction, prays for liberty to file affidavit. Let affidavit in opposition be filed within
4 weeks.
4 weeks from date, semicolon, reply thereto if any be filed within 2 weeks thereafter.
My lord.
List this matter before the next available circuit bench under the heading hearing. Next,
24.
My lord, affidavit of service may be kept on later.
if your service filed in court today.
24 also.
24 same.
My lord, 24, there is scope, my lord. But my lord,
24.
Then next circuit.
New matter.
it's a matter, my lord. It's a case
No,
of
we-
refund, my lord.
The brief is not signed.
My lord, it's a case of refund, my lord.
Refund?
Yes, so lordship, under GST Act, my lord. Seizure has been made, thereafter appeal has been preferred, thereafter they have come.
So refund also, there is no scope to pass any interim order. It has to be decided finally.
Yes.
Refund, how an interim order can be passed?
My lord, the allegation which they have made.
Then next
Let
circuit.
the affidavit to the.
Mr. Agarwal, honored advocate appearing for the state submits that he has not yet received full instructions in this matter. He prays that this matter be placed before the next available circuit bench.
Affidavit. Direction of affidavit.
He
No, my lord.
says there is some scope. I am
Yes,
placing it in the next circuit bench. List this matter before the next available circuit bench. Because he says that there is scope of interim order.
Yes, lordship.
Yes, next.
I'm grateful, lordship.
Next circuit.
25 years. Yes, Mr. Ghosh.
25.
Very urgent.
Next circuit.
Not so urgent.
No, let's say. Lord, 25.
Very urgent, not so urgent.
Urgent, Lord. 25, 27 can be taken up together, same issue.
What is
same
the
parties. Milord, I'll take 2 minutes each, Milord, 4 minutes for me. Milord, I'll make it very simple. Milord, this is a GST matter, Milord, it raises 2 very important questions of law. Number 1.
There is scope for passing interim order.
Yes. Milord, they have to come up with
If
affidavit.
there is a question of law, then without affidavit.
There is, Milord,
No question of law, no affidavit can be passed.
Milord,
That's yes.
Milord, they have to deal with Milord by way of an affidavit. Number 1 question is, the seizure process which has been done pursuant to section 67 was without jurisdiction. This is my first point. Second, Bureau of Investigation who has conducted the process, I say that the Bureau of Investigation has no powers because the constitution notification pursuant to which Bureau of Investigation was formed is ultra vires the GST Act. Lord, these are the two larger issues. Now, Lord, I am praying, Lord, let them come. This same issue is also pending before the principal bench. That writ petition is pending. Affidavits have been directed. Lord, similarly, Lord, let affidavits be directed in the instant case. Lord, 10% I have paid in appeal. 9%, Lord, I am ready to pay here and now, Lord, in course of 3 days. Let the order or appellate order be stayed. Till, Lord, the
He
disposal
wants
of the
to
writ
comply with that.
No, my lord.
He wants to pay the balance amount, pay
Yes.
10%.
Yes.
What is the, in the principal bench, what was the, any interim order, what was the order
Yes,
passed?
there was no interim order which was spread for. There is no reflection in the order. Only affidavits were directed.
Appeal disposed.
Appeal disposed. Appellate order.
So
has
you
been filed.
are preparing.
No, no, no.
112. Huh? 112. So 20% extra.
No, so you are challenging the virus of that notification.
Virus of the notification.
Then Mr. Ghosh, there is a difficulty to pass an interim order.
No, Milad, let them then, Milad.
Why? Only affidavits I am directing.
Milad, kindly Milad stays because the matter becomes.
Virus unless
Yes, yes.
it is declared as ultra virus, it has to be given effect to.
No, Milad, since Milad, a question has been raised. Now, Milad,
Maybe.
had there been the tribunal?
Then Mr.
Milad,
Ghosh,
had there been the
then
tribunal?
Mr. Ghosh, there will be a situation everyone avoiding will challenge something and say stay.
No,
The law is otherwise.
No, Milad,
Unless and until
apart from
that
the
is
issue-
declared as ultra virus,
Milad,
that provision is
Milad,
valid.
apart from the issue of virus, Milad, the entire search and seizure
But
procedure.
you are challenging the virus.
Yes,
that is the main point.
That is
So
also
let
there.
affidavits be filed.
Milad, kindly stay. Milad, had there been the tribunal, Milad,
Then I am keeping it in the next
no,
circuit.
Milad, direct for affidavit, I am ready to pay the remaining 10%. What is the difficulty?
If he approaches the tribunal, then there is an appellable order.
Yes, Milad.
This is an appellable order.
Yes, yes.
The appellate order has been passed.
No, against that, any appeal to the tribunal.
Yes, yes.
So, Mr. Agarwal, if the appellate provision is there,
Yes.
so 20%, if he pays before the tribunal, it can be stayed.
Yes.
So, he is willing to pay that.
Then he approached the tribunal.
Tribunal is not functional now.
No, but the ones.
So, let the writ petition, the virus has been challenged, let the writ petition be decided. He is putting in the balance 20% in terms of.
Within 3 days I will put in.
112A is willing to comply with.
Yes.
So meaning thereby he wants to go before the tribunal.
No. He wants to proceed with the writ petition. That is, he can do because there is no appellate tribunal for the present. So he wants to proceed. He wants to secure your interest because if he goes to the tribunal, he will be getting 20%.
Correct.
And the order gets stayed. So he wants to comply with that.
But the tribunal have the if 20% is paid. So the matter should
Mr. Agarwal, the difficulty is kindly think of your interest.
No,
Let us suppose
what is the fault?
the tribunal,
I understand.
Tribunal is constituted
Yes.
after 2 years. Let us assume. Let us assume tribunal is constituted after 2 years. This appellate order entirety gets stayed. He will not deposit a single thing now.
Yes. Correct.
But here, let us assume, this is also assumption, the writ petition gets disposed of within 6 months. And he fails, you succeed. Then you can realize the entire amount. In that case, you cannot.
Well,
The
earlier order.
yes, what is the demand? What is the demand?
Milad, kindly takes the appellate order.
So I am saying
20% remaining.
You are ready to comply with the conditions as stipulated under
As
section.
stipulated in 112 page.
Mr. Agarwal, learned advocate representing the state, raises a preliminary objection as to the maintainability of the writ petition, as the order impugned in the writ petition is an appellable one. So stop. Mr. Ghosh, learned advocate appearing for the petitioner, submits Mr. Ghosh, learned advocate appearing for the petitioner, however, does not dispute the submission of Mr. Agarwal that the order impugned as an appellable one, but submits that the instant writ petition is maintainable as the appellate tribunal is not functional. Full stop. Since it is not in dispute that the appellate tribunal is not functional, this court is of the view that this writ petition is maintainable. First of all, after hearing the learned advocates for the parties, this court is of the considered view that the dispute involved in the writ petition cannot be decided without exchange of affidavits. First of all, lest affidavit in opposition be filed within 4 weeks from date. Oh, you have to serve upon the Advocate General.
I have to.
Oh, yes, yes.
Yes, I'll comply with that.
Let affidavit in opposition be filed within 4 weeks.
Let it be, my lord, subject to, my lord, their consent, let it be, my lord, 6 weeks or 8 weeks. Because, my lord, those formalities requires to be completed. I have to serve copies, my lord.
Let affidavit in opposition be filed within 6 weeks from date.
Yes.
First of reply thereto, if any, be filed within 2 weeks thereafter.
3 weeks, 3 weeks, my lord.
3 weeks thereafter. List this matter.
And copy to Advocate General.
What should be done, Mr. Ghosh, if this matter is pending before the principal bench?
Well, I'll serve a copy on the Advocate General. Well, I'll serve a copy on the Advocate
You want the
General.
matter to be heard here.
I will press
Same
for
issue.
it. I'll press for it. Because principal bench, my lord, no one knows when it will be finally heard. My lord, circuit, my lord, still if honorable judge agrees to hear it for at least 2-3 days, it can be done.
List this matter before the next available circuit bench under the heading hearing immediately after expiry of the
Yes.
time fixed for exchange of affidavits. ঠিক আছে একদম উপরে লিখুন যে where have you challenged the virus prayer?
My lord, that prayer, my lord, requires to be incorporated because that prayer has not been specifically read. But
pleadings
it is there. Pleadings it is there.
you are sure there is pleadings?
Yes, my lord, sure.
Mr. Ghosh, learned advocate, appearing for the petitioner submits
My lord, page 14, my lord, takes the writ petition, page 14.
1-4.
Yes. 1-4, my lord, would take
Mr. Ghosh,
Ninth-
learned
ninth
advocate
line
of the
from the top.
petitioner draws the attention of the court to the averments made in the writ petition and submits that the notification number 1077-FT dated June 21, 2017 he submits that the notification is ultra vires the parent statute.
Yes.
Full stop. On a query of the court, এটা একদম প্রথমে দেবে না? On a query of the court as to whether the petitioner has prayed for declaring such notification as ultra vires, Mr. Ghosh candidly submits that through inadvertence, such prayer, through inadvertence, such prayer has not been incorporated, though the pleadings in support of such relief has been incorporated in the writ petition.
Yes.
So, stop. Mr. Ghosh prays for leave to
Yes.
amend the prayer portion of the writ petition. Full stop. Such prayer is allowed. Full stop. Leave is granted to the learned advocate on record of the petitioner to amend the prayer portion of the writ petition insofar as declaration in that regard করে দিন, in that regard here and now.
Yes.
ঠিক আছে? Amend the here and now. Full stop. Let a copy of the amended writ petition because Mr. Ghosh, we have to serve a copy of the amended writ petition because
I will.
let a copy of the amended writ petition be served upon the learned Advocate General, High Court, Calcutta. Here, additional Advocate General.
No, only one.
Milord, the rule says Advocate General, I have to send it to Calcutta. If he delegates here, Milord,
So you serve upon both.
I will serve upon
So that otherwise,
Yes.
let a copy of this writ, let a copy of the amended writ petition be served upon the learned Advocate General, High Court, Calcutta, learned additional Advocate General, Jalpaiguri Circuit Bench, and the learned advocate and Mr. Agarwal, learned advocate, appearing for the state. How much time you can serve?
My lord, 2 days.
Within a week from
Within a week from date.
within a week from date. ঠিক আছে? আচ্ছা, এবারে এটা হচ্ছে একদম উপরে গেল। তারপরে ওই যেটা হচ্ছে এফিডেভিটস এর ডিরেকশনসটা হয়ে গেল। এবারে লিখুন Mr. Ghosh submits that the petitioner is Mr. Ghosh submits না করে করুন by placing reliance upon section 112 within bracket 9 of the 9 says stay.
Yes.
If he complies, stay.
Yes.
Upon section 112 within bracket 9 of the CGST Act 2017, comma, WBGST Act 2017, comma, Mr. Ghosh submits that in the event an approach is made before the appellate tribunal by filing an appeal under section 112(1) of the said Act, and the preconditions stipulated under section 112 within bracket 8 of the said Act is complied with, comma, the appellate order passed under section passed in an appeal under section 107 of the said Act shall remain stayed. Full stop. He submits that the petitioner is ready and willing to comply with the provisions laid down under section 112 within bracket 8 of the said Act, and an interim order and an interim protection be granted in favor of the petitioner. Full stop. Mr. Agarwal, learned advocate for the state, does not object to such prayer of Mr. Ghosh. Full stop.
So my lord, the compliance of 112(8), the time should be for the petitioner, so.
Yes.
Within a fortnight.
Fortnight.
There shall be an unconditional order of stay of operation of the appellate order dated
My lord, 12th July.
July 12th, 2023, for a period of fortnight from date.
Grateful. Extremely grateful.
In the event the petitioner complies with the stipulations contained in section 112(8) of the said Act within the aforesaid time limit, the order of stay shall remain in force. The order of stay shall be extended till the disposal of the
Extremely grateful.
with the full stop. Yes.
Yes.
Anything more?
No.
Nothing more is.
My lord,
It's a for the petitioner only.
my lord, 25, 27 is similar.
Similar.
Yes, 25 is similar with regard to the financial 18, 19. That
তাহলে এখানে যেটা রয়েছে না এটা the petitioner, এটা ফার্স্ট লাইনটা করে দিন তো। The petitioner has challenged the, একদম প্রথমে করে দেবেন, তারপরে ওইটা না দাঁড়া 20, এটা কি কত 25 তো। The petitioner has challenged the appellate order dated 12th July 2023 in respect of the demand pertaining to period 2018-19.
19, yes.
ঠিক আছে, and 20, এটা হচ্ছে 25 হয়ে গেল, একদম উপরে দিয়ে দিলেন, তারপরে যেগুলো
27 will not, everything will be same.
না একদম উপরে দিয়ে দেবেন, তারপরে লিফটটা দেবেন, ঠিক আছে? আর 27 এ সেম হবে। There also you have not paid for.
1920.
There also the
No.
you have to amend your requisition.
Yes, I have to amend.
Same.
ওটা হচ্ছে which period?
Period.
1920.
1920 for the period 1920 and order dated
Same.
same order.
Order was common. The appellate order was a common order.
Order date the same. Yes. Yes.
26.
দাদা আমার কাগজটা চলে গেল। 25
Lordship, item number 26, kindly fix the next citizen.
Why?
Lordship, advocate on record due to high fever, he did not come today.
Where is Mr. Bhownik?
He is in high fever.
He is the advocate on record. Who is the advocate on record?
Mr. Joydeep Kanta Bhumi.
Jalip Kanta Bhownik. You are his chamber junior. Yes. Have you gone through the brief?
He did not hand over the brief, Lordship.
He has not handed over the brief. Go through the brief. I am handing over my copy. I am keeping at 115. Yes. Din.
That time,
You go through the brief.
Lordship, I appear for the petition in 28 Lordships.
Yes.
Lordship, this is that matter when I requested a leave of your Lordship yesterday. Lordship, 30th of December 2023, morning 12:15 a.m., my vehicle was detained and an order for physical verification was passed that the goods, that the invoices and the quantity has to be verified. Lordship, may kindly take page 22.
Mr. Kanoria, is it very urgent or I can...
Lordship, since 13 days, they are just keeping my vehicle and all documents submitted, they are verified. Now they have issued a show cause of 40 lakhs, Lordship. And
Give a reply. Yes.
No, Lordship, reply already submitted. Lordship, reply submitted before show cause. But how they have dealt it, Lordship, I will take 5 minutes of your Lordships.
Reply. Take it.
No.
Lordship, reply dealt with. Reply dealt with, Lordship.
Mr. Agarwal says no.
Lordship, give me 5 minutes, I will show you your Lordships. Give me 5 minutes. Lordship, may kindly come to page 22 once.
The 49 is irrelevant.
Page 20.
Lordship, kindly take page 22. This is the first MOV 01 when my goods were, the statement of the driver was taken. And then Lordship, may kindly come to the relevant page at 27. The order of physical verification. Page 27, Lordships.
Yes.
Lordship, they tick this, the third in the box, the third column, the third row, the genuineness of the goods in transit and the tender documents require further verification.
Yes.
They do this on 30th of December, Lordship. The day they, in the morning, 12:15 a.m., they have detained my vehicle. Now, Lordship, they give me a physical verification report on the same day. That is at page 30.
Yes.
Form MOV 04. They say, Lordship, they have verified the transport, the document number, the goods, and there is no difference. Kindly takes up the table at page 30, Lordships. Page 30, there is a table, Lordships.
Yes.
First, tendered invoice number, my invoice number of my supplier, description of the goods in the conveyance, quantity as per invoice, quantity as per physical verification, difference nil. No difference.
Yes.
So they are satisfied that the goods along with the invoice and waybill was valid. It is not a case of expiry of waybill.
Quantity as per physical verification and quantity as per invoice.
Matching. It is matching, Lordship. Now, Lordship, kindly comes to page number 33. After this, on 31st December, even after verifying the goods, they issue me a detention order.
Yes.
Page 33. Now, what they say, Lordship, in the 33, Lordships, kindly takes the Lordship, after the first box, I am reading from the first paragraph, Lordship, from the above said reasons, an order of physical verification, goods and documents was issued in MOV 2, which your Lordship has just gone through, and served on the owner of the conveyance. A physical verification and inspection of goods was conducted on 31st December by the STO BI in the presence of the owner, and the report was drawn in MOV 4, which your Lordship has just seen. Now what they say? discrepancies noticed after physical verification, Lordship. They tick goods not covered by valid documents. Now, when they detain the goods, they say genuineness of the goods in transit document needs to be verified. After they verify it, they issue a detention order stating that the goods are not covered by documents. Now, Lordship, what story they have made? Kindly text, Lordship. Kindly text, Lordship, the order of detention at around 12:15 a.m. The last paragraph of page 33.
Yes.
At around 12:15 a.m. on 30/12, one goods vehicle bearing number this was intercepted at PWD More by the officers of BI North Bengal during the routine wayside checking. The goods loaded vehicle was moving from Kishanganj, Bihar to Alipurduar, West Bengal. The driver of the vehicle was asked to produce documents relating to the goods being transported in his vehicle. The driver produced the following documents of the goods transported in the intercepted vehicle: a copy of tax invoice dated this, a copy of e-way bill dated this. The goods loaded is physically verified on 31/12 in presence of the driver, and a report in MOV4 was drawn by the team of STO. The following goods are found as mentioned. The same table they have again copied. Now they say, now, Lordship, this paragraph assumes very importance. From the produced documents at the time of interception, the back office investigation of our GST portal. What is this? I don't know, Lordship. And after receiving the inspection report dated 30/12/23 drawn by Sri Ashish Subba, Alipurduar zone, Alipur, the following inferences are drawn. The inspection report dated 30/12 drawn by Sri Ashish Subba, this has never been supplied to me, revealed that the recipient of the consignment supported by tax invoice number this issued by Madan Kumar Saha, Messrs. Royal Enterprise of Birpara Tea Garden, is at his declared place of business is non-existent. It is also revealed that. Now, Lordship, what they do? Kindly, Lordship, takes this. Before reading, I will just tell you what they have done now. On 30/12 morning, 12:15 a.m. in the morning, they halt my vehicle. They verify. They pass, they give a report. Now, in the same day, afternoon, they send a team of GST officers to the recipient's address to verify whether the recipient is there or not. But in 129, this cannot be done. This is not a question of section 129. 129 says, when the goods in movement, my Lordship, my advocate on record will hand over you 129. Lordship, it is in my petition also. It is, I've extracted this in my petition, Lordship. Lordship, kindly takes page number 7 of the pleadings. It is there in my petition.
All right, I'm taking the act. Yes.
Section 129, Lordship.
Yes.
Lordship, I am placing it before your Lordships. Lordship, it says, notwithstanding anything contained in this act, where any person transport any goods or stores any goods while they are in transit in contravention of provision of the act or rules. Now, which provision, Lordships? Kindly takes up section 68. Kindly takes up, Lordship, section 68. Lordship, my Lordship, is that section 68?
Yes.
Lordship, section 68, inspection of goods in movement. The government may require the person in charge of a conveyance carrying any consignment of goods of value exceeding such amount as may be specified to carry with him such documents and such devices as may be prescribed. The details of documents required to be carried under subsection 1 shall be validated in such manner as may be prescribed. Where any conveyance referred to in subsection 1 is intercepted by the proper officer at any place, he may require the person in charge of the said conveyance to produce the documents prescribed under the said subsection and devices for verification, and the said person shall be liable to produce the document and devices and allow inspection. Lordship, the scope of the provision 129 read with section 68 is inspection of the goods and the documents.
What is the, Mr. Kanodia, what is the prescribed devices and documents?
Lordship, kindly take some rule 138A. Lordship, 138, only 138, rule 138, Lordships. May I place before your Lordships?
Yes, yes.
Lordship, rule 138, information to be furnished prior to commencement of movement of goods and generation of e-way bill. every registered person who causes movement of goods of consignment of value not of exceeding 50,000 rupees in relation to a supply for reasons other than supply or due to inward supply from any unregistered person shall before commencement of such movement furnish information relating to the goods specified in Part A of GST e-way bill 1 electronically on the common portal along with such information as may be required on the common portal, and a unique number will be generated.
Yes.
So then lordships may kindly take rule 138 rule 138 prescribes this, and lordship 138A.
138 be relevant.
138A now.
Yes.
Lordship. That person in charge of a conveyance shall carry an invoice or bill of supply or delivery challan as the case may be, and a copy of the e-way bill in physical form or the e-way bill number in electronic form or mapped to a RFID embedded on the conveyance in such manner as may be notified. So RFID has not yet been notified, lordship, by the commissioner.
Yes.
Provided that nothing in clause B of this rule shall apply in case of movement of goods by rail or by air or vessel.
This why so is not applicable.
Lordship.
Yes.
So, lordship, these are the two documents which are required: an e-invoice and an e-way bill.
According to you, 138A was complied with.
It is.
There is no compliance of 138A.
Lordship. Now what they do, lordship? Now they go to the recipient's address.
Yes,
recipient is not found.
What do you say?
Lordship, kindly give me 2 more minutes.
Yes.
Lordship. Now what they make up a story? They go to the recipient's address. They say recipient was not available. Then they go to the landowner. Landowner was not available. So they go to the wife of the landowner. They take a statement of the wife of the landowner, and the wife says that I don't know whether my husband has given this rent to Mr. Royal Enterprise. Now they issue me a detention order stating that the wife of the landowner does not know you. So therefore your goods are liable to be detained. In my reply to this, I give an affidavit of the landowner stating that this premises has been given on rent from 1st October 2023 to Mr. Unus Ansari. He gives it on an affidavit.
Is that at page 43? Where is that?
That affidavit, lordship, my reply starts at page number 37 onwards. To the inspection this detention order, I filed a detailed reply. Page 37, lordships. Yes. I gave the screenshot, and then I gave an affidavit which is at page number 43, lordship.
How this was dealt with?
Now they say this cannot be dealt with because it is impossible that the wife of the husband does not know about this. Kindly comes to the show.
Where is it?
Kindly takes page 47. How they have dealt with.
47.
Page 47, lordship. Lordship, may I read first, second, third, fourth, fifth paragraph, lordship, against the detention order. My lordships have got that, against the detention order. May I place before your lordships?
Yes.
Lordship, against the detention order so issued in MOV 6 dated on 31/12, my authorized representative Tuklari Saran Jha, stated to be the AR on behalf of the Royal Enterprise, appears on 6/1/24 and produces a copy of affidavit made before notary GC Sagdar of Alipurduar, having number this along with the submission. Copy of the affidavit made by Shri Madan Thakuri, who is the actual landowner, lordships, declares that he has rented the premises located at Subhash Palli, Birpara district, Alipurduar to Mr. Unus Ansari and has entered into a rent agreement dated 1/10/23 with the tenant for his business purpose. Mr. Madan Thakuri has further declared in his affidavit that statement made by his wife, Ms. Meena Thakuri, on 30/12 that they have not given the premises on rent to Mr. Unus Ansari is factually incorrect, and that his wife is not aware of the rent agreement made between Madan Thakuri and Ms. Unus Ansari. Now, lordships, kindly turns to page 48, how they have dealt it. Next page, lordship. These are the 2 paragraphs of my submission they have extracted. Lordship, page 48, para number, second last paragraph. Consider the affidavit.
Yes.
Consider the affidavit.
Seen.
Lordship, just 2 lines. The
Yes.
last 2 lines. Lordship, 2 lines, Lordship.
Yes.
He says, consider the submission made by Mr. Ansari and affidavit in support of his claim, running the business from Subhash Ali. However, as discussed, the statement of Mrs. Meena Thakuri, wife of Madan Thakuri, cannot be ignored or rejected simply on the basis of affidavit, where the signature of Madan Thakuri does not match with that as per the agreement submitted at the application. Further, the rent agreement is this. It is also claimed that Mrs. Meena Thakuri was unaware of the rent agreement between Mr.
Kanodia, there is a discrepancy with the date of the rent agreement and in the affidavit.
No, Lordship, I will tell you what was that. Lordship, in the rent agreement, it was uploaded in the portal on 3rd of October. But the rent agreement starts from 1st of October. So my affidavit states 1st of October.
Yes.
Lordship, but under 129, if I humbly submit, Lordship, if I ask this question to myself, how can this proceeding of inspection of my registered place of business be carried under 129? Now, Lordship, what they say in the last paragraph, penultimate paragraph of page 48.
Yes.
But Mr. Adhikar, it is so claimed that Mrs. Meena Thakuri was unaware of the rent agreement between Mr. Ansari and Thakuri. But Mrs. Adhikari has already categorically stated that Mr. Dilip Das runs the business from the declared place. So there is no question of Mr. Ansari, proprietor of Royal Enterprise, running the business. Further, she has claimed that the signature in the rent agreement does not belong to her husband. Surprising, the affidavit is completely silent. Now, Lordship, when the person who is actual landowner, how much importance the government is giving to his wife's statement? Lordship, I can produce the landowner before your court. He is ready to come before your court.
Yes, Mr. Agarwal.
My lord, actually, this transit, in the goods are carried through the transit. So there is all the formalities are there, like the MOB1, MOB2. So now the SOCOG is given and the date is fixed on 11/1.
11th of January.
SOCOG, because that is before invoking 129 penalty. So we have not decided that whether it will be levied or not. So they will appear and reply to it, and for personal hearing, the date was given on 14/1. So there.
Where is that? Where is that?
Yeah.
Page 40.
Page 49.
49.
Lordship, all my replies already on record. They have made up my mind. They have made up their mind and issued me this. What extra I will submit before the officer, Lordships?
Mr. Kanodia, since 11th is the date, that is tomorrow. So I'm keeping it the first day of the next circuit bench. So let him take a decision because it's tomorrow.
Lordship, but he has already taken a decision. He has dealt with my reply. What additional I can submit, Lordship? He has made up his mind and issued this.
Kanodia is also right in that.
No,
because
he has made up his mind, Lordship. Here, I have given him an affidavit, I have given him every document, and he has made up his mind and issued a show cause. What more I will submit?
Because I am a creature of history. So I have to follow the rules and laws of the GST.
Mr. Kanodia, only one thing. So I will be directing the authority to decide your show cause without being influenced by that findings. Then you are saying
it is the same person, the same officer. The same person, Lordship, the rule of adjudicam generis, Lordship. Lordship, my only question.
What is this?
Lordship,
29.
No,
Lordship, 129, there is no scope in this case. They have incorrectly invoked.
For a minute.
Yes, 138A.
No, 138.
138, yes.
Information for this prior to commencement of the movement. If the information is incorrect, so whether the authority cannot verify the veracity of the whatever the information given in the EBV.
I would like to deal with that, Lordship. Once my learned senior submits, I would like to deal with that. Very pertinent question raised by my learned senior.
Mr. Kanodia, let them take a decision, you challenge that.
Definitely.
Since I'm pending.
Lordship, kindly give me some protection, Lordship. Lordship, kindly. Lordship, in the 129, can the registration proceedings can be combined with 129? They have stated that the documents are correct, the goods are correct. How can a registration process which
7th is the only date? Let them decide this. I will.
Lordship, then in that case, give Lordship, the liberty may be given that the goods may be released on bond, Lordship, because they will ask for 200% penalty, Lordship. The penalty is 40 lakhs.
Bond nine one.
Lordship, the bond may be given, Lordship.
The law permits.
And Lordship, the landowner may be also called for hearing, Lordship. This is very important, Lordship.
That has been given, 14.
The order under the order dated you have challenged the show cause notice.
Lordship, I have challenged the show cause notice, Lordship.
The show cause notice dated 7th of January 2024 is under challenge
Lordships.
in this writ petition. Full stop. It is not in dispute that the petitioner has replied to such show cause notice.
Not reply, man.
Lordship, I have replied to the MOV 6, the detention order.
No. So how you submit a reply tomorrow? Can you?
Lordship, I will submit the same documents again. I cannot bring in new facts.
Submit. Otherwise, they will be saying that you have not replied to that.
Yes, I will submit it by tomorrow, Lordship.
By tomorrow.
By tomorrow, Lordship.
And tomorrow is the date.
Tomorrow is the date. I will go and submit a hard copy reply during the course of hearing.
All right. Kivala, it is not in dispute, Nakore. Mr. Kanoria submits that since the show cause notice such and such is under challenge and this writ petition on a query of the court as to whether any reply to such show cause notice has been submitted, Mr. Kanoria submits that no such reply has been submitted since the petitioner has challenged the show cause notice in this writ petition. Stop. Upon going through the materials on record, this court finds that the Assistant Commissioner of State Tax, Bureau of Investigation, North Bengal Headquarters, Jalpaiguri, directed the petitioner to show cause on or before 11th of January 2024. No, this is the, Mr. Agarwal, this is the date for filing the reply. How soon you will decide that? What is any date fixed? No. Oh, yes, 14th. Yes. 11th of January 2024, and the petitioner has been directed to appear before such authority on or before 14th of January 2024 at 11 a.m. Since taking into consideration the fact that the date of hearing has been fixed on January 14, 2024, and since Mr. Kanoria submits that the petitioner shall file the reply to the show cause within the file shall show cause, file the reply to the show cause on 11 on or before. I'm making it on or before 11th of January 2024. So I'm disposing of this writ petition. Let them decide what keeping that.
Lordship may dispose. Lordship, just two observations, Lordship.
Yes.
That where the officer should consider whether this registration portion can be invoked under section 129. Your Lordships are not deciding it.
Restricting I will be giving you liberty to raise all points, including the prayer for release also.
Yes.
Including prayer for release on furnishing a bond, Lordship.
You make a prayer in account that will be considered in Kiolam, and also shall file the reply to the so-called notice on before given January 24. No useful purpose will be served in keeping this writ petition pending. Full stop. Mr. Kanodia's, by drawing the attention of the court to the order of detention, the section 129(1) of the CGST 2017 and WBGST 2017, Mr. Kanodia submits that the concerned authority has already made up his mind. Full stop. Full stop. W number such and such. After hearing the learned advocates for the parties and considering the materials on record, this court is of the considered view that the interest of justice would be subserved if he is what respondent?
Lordship, he is respondent number 1.
The respondent number 1 is directed to take a decision on the show cause notice after considering the reply to be submitted by the petitioner within the time limit stipulated herein before, and by passing a reasoned order in accordance with law upon giving an opportunity of hearing to the petitioner or his authorized representative. Full stop. While adjudicating the said show cause notice, the respondent number 1 shall take an independent shall decide while deciding the said show cause notice, while adjudicating the said show cause notice, the respondent number 1 shall not be shall decide the same independently without being influenced by the observations made in the order under section 129, made in the order on. This was the observations
in the show cause, Lordship. It is made in the show cause.
With
MOV 6, Lordship, detention order is at page 33.
The show cause notice without so that you are replied to. So it likhta hobe na
7th January.
না এটা কি বললাম while adjudicating ওটা কেটে দিন কি বললাম shall decide in accordance with law this is order hearing to the petitioner or his authorized representative. The respondent number 1 is directed to hear the said matter on 14th of January 2024 and to communicate the decision.
My lord.
You tell how much time will be the reasonable.
As per statute, they have to pass order within 3 days. As per statute,
within
they will pass this whole exercise. They have to complete by 20th January, because it will become time barred.
Oh, 20th January. So you will be doing by that. So I'm not making.
Lordship may not fix the date. Lordship's one request, Lordship.
I'll take up the hearing and to dispose of the same in accordance with law.
Lordship, the personal presence of the landlord.
And to dispose of the same within the in accordance with law. Full stop. Mr. Kanodia submits that the goods may be that the goods as well as the conveyance,
Both, Lordship.
as well as the conveyance which has been detained may be released upon furnishing the bond.
Bank guarantee.
Bond. not bank guarantee bond.
Upon furnishing the bond, full stop, it will be open to the petitioner to make such a prayer before the authority, and in the event such prayer is made, the respondent number one shall consider the same by passing a reasoned order.
My lord,
Lordship, and the lordship, the presence of the landlord is required, lordship. The personal presence of the landlord. That may be given. Lordship, that liberty may be given to me, lordship.
The petitioner will be at liberty to produce materials, documents and evidences in support of his claim. Evidences in whatever mode.
Grateful to you, lordship. Grateful to you.
Bank guarantee, otherwise there will be.
You will be making that prayer, consider that, reject that prayer.
Again, there will be problem. That's why.
No, I have only recorded his submission. I have said he will be making a prayer, you consider that. It is not.
Statute says bank guarantee.
So otherwise the
You reject on that ground.
purpose will not serve.
No, I have only recorded his prayer before this court. If he makes you deal with that, he can change his mind, he can make other prayers.
Grateful to you, lordship. Grateful to you.
Please, item number.
Yes, Mr. Bhattacharya, what?
Yes, they are on the same page. So, my lord, this is the order, and I have made a.
Yes, annexed in page number 100.
Yes,
The document.
You are agreeable to this order?
I have made the necessary, indicated the necessary changes that my lord will kindly please to make. Only one paragraph, my lord, needs to be struck out because there the appellate authority did not have any observation regarding the GSTR.
Yes, fine.
That is.
All right, so your submission with this paragraph will be, you have indicated
I
that.
have indicated, my lord.
Ashun.
Subject to my lord's pleasure.
Yes, same order. যা আছে যে কারেকশন আছে শুধু এই প্যারাগ্রাফটা হবে না, এটা কাটা আছে, আমিও কেটে দিয়েছি এখানে।
And my lord, affidavit of service will be kept on the record.
Affidavit service kept on record. Yes, what is this? That is 2472.
This is
Oh, this is another extra copy you have given. You can keep it for other purpose.
Just for comparing, my lord.
Yes, yes.
I cannot question your ignorance, no?
Yes, who is opposing you?
Grateful, my lord.
I've served, no one has observed.
State, who is appearing?
Upon the state as well as upon the.
No, he is appearing for the state usually. You do not know.
Who has appointed? From the criminal panel, my lord. From the criminal panel.
Yes, from the criminal panel we do not know.
In the morning, someone has prayed for accommodation.
Wait for time.
For Passover.
You know here who is appearing in the criminal panel.
Sierra.
I am keeping it tomorrow. Or come at 3. Bring the other side.
Shall I come at 2 months? Oh, yeah, 3. Will
You can come at 2 also.
3 is better.
3.
Hello.
No, not at 3, Mr. Pal, come at 2.
Well, 2, I'll be engaged in photo.
After that come. Yes.
26, I just come from. Give me 15 minutes. After postcard, I will.
15 minutes. 2 p.m.
No, Passover matter, first time, 7, I got 7, would you lord?
Next circuit. Difficult now.
Then, my lord,
Because they will not be able to.
Then, my lord, I am only paying leave to file the affidavit of service because I have to leave. Calcutta, my lord, that's why.
If it is service, file on the next day.
On virtual mode, my lord, I will.
Oh, all right. Which item?
7.
7, affidavit of service filed in court today is taken on record.
Okay.
As paid for, list this matter before the next available circuit bench. Mr. Ghosh, what do you say?
Milord, if before Milord rises, Milord, under grave urgency, Milord, one matter it has been affirmed today, 5. If it can be taken up tomorrow.
What is the urgency, Mr. Ghosh? It's very difficult.
Milord, the livelihood of 1,000 workers are involved. Had it not been so, I wouldn't have done.
It's very difficult.
Milord, I won't take more than 5 minutes. If I can make a cut, I will be able to in 5 minutes, otherwise always. Milord, not more than 5. Very simple otherwise. Milord, I will serve upon Mr. Sahar today, Milord, so that he can take his steps.
All right.
Number 2. It has been affirmed, Milord, kindly.
Leave is to be granted.
Leave is to be.
Leave.
Tomorrow. I won't travel, Milord, your lordship today, Milord, tomorrow.
Yes,
Old motion will be taken up.
Mr. Bonik, it's difficult because I do not know because
Yes, yes.
you have some of you have submitted the some of the orders is not yet been uploaded.
Yes, yes, yes.
But for that, my information is that it has been uploaded, most of them, some may not have been, but there is some problem with regard to servers.
Yes.
Because my officers can find it out from the server.
Yes, yes.
So there may be some problem with regard to that. For that, you are not able to
Yes, yes.
see those.
Mr. Himanshu Rai is the other side, old motion matter.
No, this is next circuit bench.
Mr. Binay Sarab appearing, my lord.
Tomorrow
Will not
today.
much time, my lord.
Mr. Rai, it's
Mr.
not,
Sarab is appearing.
Mr. Rai, the question is not taking much time for passing the order. The question is transcribing.
Mr. Sarab, join, Mr. Sarab.
My lord, I am there, my lord.
Mr.
My lord, these matters, my lord, these are, my lord, kindly allow me 1 minute, my lord.
Not in for the next circuit bench.
No, my lord, kindly allow me, my lord.
Mr.
My lord,
Mr. Saraf, it's difficult because the orders are to be typed.
no, my lord, your lordship, it will not require because the issue is a covered issue, your lordship.
Maybe since
My lord, my lord, the difficulty, my lord, the difficulty is, my lord, your lord, I cannot express in the open court, my lord, difficulty is that this tax matters, my lord, every time it is very difficult to get it heard. That is why it is pending for so long.
Saraf, Mr. Saraf, I have taken up many matters. I have taken up our past orders, but the problem it is to be transcribed. If Mr. Saraf, I cannot take it up today. If I find there is time, I will take it up tomorrow.
My lord, kindly take it up today, my lord.
Because
I'll
if,
argue.
If possible,
today, are made up to date and other things subject to otherwise try your luck.
Till the end, we are waiting, my lord.
No, in that case, I can leave for session.
Kindly, sir,
So I am submitting.
because my lord, in that case, I can, sometimes they are taking.
My lord, this matter has become jinxed, my lord. Every time,
They are from Kolkata.
my lord, it is becoming jinxed.
Item number 40 here.
From secondary, we are waiting here.
Covered by your lordship judgment, last time your lordship.
All.
My lord, Himanshu is waiting for this matter, my lord. He whole last week he waited, my lord.
Simona, it's not a matter of 2 minutes. These orders are to be transcribed.
But your lordship, this matter the pension.
Kindly bear with the court because I appreciate-
Covered by your lordship. So your lordship direct the state to take the instruction properly.
yes, who is appearing for the state? Mr. Burman, you are appearing. Kindly take it.
It is short matter, your lordship, only 1 or 2, your lordship, earlier, your lordship, offense, this is the only copy paste in the order, only date change.
All right, let me see if I can tomorrow. I will see. Consider.
My lord, your lordship, will your lordship be taking up 32, 33?
Orders have been fixed. I will dictate in open court. So from one matter, Mr. Pal's matter, and I think another matter has been fixed. What is it? Oh yes, Mr. Bonik's matter. These one orders I will dictate and 2 matters.
Today, 30.
My lord, 32, 33 will your lordship be taking up in the second half?
Mr. Rai, it's difficult.
And then when I do it from tomorrow, have to go back.
Tomorrow, Mr. Rai, it's difficult because the orders have not yet been fully transcribed. It has to be signed. It is to be uploaded. For that, so it's the difficulty. I have only two air courts. They are living at 9:30 to 10 every day.
Yes.
And till now, they could not complete, could not.
Yes.
And yesterday you have seen that those matters were. So try your luck in the next circuit bench.
I do from there or next circuit.
Tomorrow it's difficult because I have only kept some urgent matters. One has been mentioned with regard to some medical admissions. Medical admissions here now, just now, Mr.
My matter is not so urgent.
That is why Mr. Rai, next circuit.
Lordship, one content application, you have to state pending.
My other side is here. My other side is here.
Your other side is here.
Lordship, in the contempt application, one contempt application, your lordship, petitioner did not receive any amount, so the matter is kept pending and the hard by from the principals. I am ready.
All right.
Other
I'll
side is
pass.
there.
Lordship, only one, item number 31, I am preparing next circuit.
Ah,
Mr.
yes.
Shop Council was
Item 31,
34.
34, 34 টা not this week করে দিন তাহলে next circuit হবে। ঠিক আছে? Not this week করে দিন।
Will your lordship be taking up 32, 33 in the second half, your lordship?
No. 32, 33 may not reach in second half because some foreigners matters have been fixed.
Lordship, content is.
Well, reaches, my lord, will your lordship be taking up? If it reaches, my lord.
Yes, Mr. Saraf, what is submitting?
Mallam, what I am requesting is that, my lord, if the other matters which are fixed are concluded, will your lordship be taking up 32, 33?
32, 33 cannot be taken up today because the foreigners matters and two other matters have been fixed. That will continue.
Okay, so tomorrow, your lordship, will your lordship allow this matter to?
Next circuit.
Lordship.
Yes.
But kindly, my lord, kindly.
Task feed for the principal, then judicial order is required. Otherwise, file is.
All right, let me see content. It is appearing in the list. ওটা একটু মার্ক করে নিন দেখছি তা।
Lord, 32, 33, my lord, kindly keep tomorrow, my lord.
স্যার আমরা ওয়েট করবো তারপরে
Item number 87, my lord, on the last, there was a direction to take instruction from the petitioner whether he is willing to pay the sum or not. So it is a very urgent to issue an interim order, my lord, as the trial court has already issued a warrant against the petitioner.
What amount he is willing to pay?
My lord, on the last occasion, on the application, he has already submitted that willing to pay the sum of 1 lakh rupees deposited. Deposited the amount.
Who is appearing for the other side?
My lord, it is on the admission statement.
87 টা একটু দেখুন তো। Why did you mention in the morning?
And the item number was already listed, my lord, therefore I am mentioning it here. Last.
Item 87 টা একটু বার করে দেখুন। Yes, call the list.
এটা দুটো item number 3 and 4. One page you are missing.
Can my lord hear? Can my lord hear me?
Yes. Yes, now I
Can my lord
can,
hear me?
now I can see you.
She will not do. Can my lord hear me? But, I've been told, my lord, Mr. Mukherjee has relied on Rule 30.
No, Rule 30, Mr. Basu, though Mr. Mukherjee tried to rely upon that, I said that the question does not arise since the permission in whatever way has been granted. In whatever way has been granted. So, deemed sanction, Rule 30 need not be.
No matter of application. Now, my lord has to see what is the sanction, why, how is the sanction has been granted,
Yes.
and who has granted. Who has granted the sanction? Sanction has to be granted in terms of Form 4 under Rule 17.
Yes.
And it will be considered by the Panchayat, and Panchayat will then grant a sanction.
Mr. Basu
Ask for deposit of
did not submit this at the first instance. I pointed out this, that the Pradhan cannot. That by the Gram Panchayat.
that. I know that. That is my challenge. Pradhan cannot, and the manner specific. Now, my lord, another thing, my lord, Mr. Mukherjee has submitted, I've been told, subject to correction, that these are all guidelines.
No, no.
I beg to differ with the submission of Mukherjee. It cannot be a guideline. It is statutory force.
Mr. Basu, he did not say that. He said that he submitted, Mr. Mukherjee submitted that he is having a SOP, which shows the sanction referring to that. He has not referred to that. He did not say that these are merely the guidelines. Rules are merely the guidelines that was
grateful. No, then
he said.
I thought that I was astonished. So that I submit this. Now, my lord, only thing your consideration by my lord, first matter, the direction was not complied with in this true sense.
Mr. Basu,
And if your lordship relegate
anything more you want to submit?
my lord, if your lordship asks anything from me, any query, I can hear. I am can satisfy my lord.
No.
Because I have cited the judgment of 2000. It specifically said what is the mode.
Yes, yes. All right. Mr. Both of you need not remain because there are one or two small matters. After that, I will start dictating. Because let me.
Very well, my lord. Then very well, my lord.
Ask juniors to be present because in case there is some actual things so that they can assist. Your junior.
Yes, my lord, to be there. No problem. If I am not, I will try to be there. If I am not, my advocate will be there. Grateful to my.
Grateful to your lord.
Next.
6. Item number 6. 6 was on the state.
Yes, Mr. Paul was there. You were not appearing. Mr. Paul was there. He has filed this application for modification. What do you say to this?
Actually, he's before, he's on index before on the code number 1. He's before code number 1.
All right, you wait because he was present yesterday, day before yesterday, today in the morning also. Yes, pass over next.
26. My lord, I am for the petition.
Yes,
My lord, my innocuous prayer would be, if your lordship can take the page number 43 and 44 up to 45.
you are for?
I am for the state, my lord.
Yes.
Now, if your lordship can take the page number 43 to 45.
Yes.
Then on order was passed, my lord, by the learned trial court. And in the ad interim injunction order was passed. In the page number 44 of the last portion, 44. Ordering portion, your lordship. Last line of the ordering.
Yes.
The copy is served to the Monogory PS along with the copy of the plaint. May I write, your lordship? An order was passed in favor of myself. And the page number 45.
Police station is the party in the suit.
No, my lord. For that reason, we have made a prayer separately.
What for this plaint and the order of injunction was served upon the police station
That is
while passing an ad interim order of injunction?
That is
Mr. Bhomik?
passed by the learned trial judgment. It is not our prayer. And now, on the basis
And this order of injunction was subsisting till?
my lord, till today. That is a point.
No. Yes.
45.
But it was till 16th of March. That direction was till 16th of March.
My lord.
Direction to the police. Yes. What happened after
No,
that?
my lord, we have made a representation there. But they did not give me any receipt.
Where is the
That is
representation?
my representation. I am handing.
No. You have not annexed.
No. And subsequently, I got the track report, so I could not annex.
What is the representation? You have to give him a copy.
Not here. Petition. It is public function. এরকম দুটো ছিল তো
Sir, Bhomik, this is a very vague application, prayer for representation.
My lord, actually, my application.
Your civil suit is pending. Approach the civil court.
Well, we have already.
Are you suggesting that the civil court is powerless to implement its own order?
No, my lord.
Approach the civil court.
Then my lord, matter may be kept in abeyance. I will approach for the civil court.
What abeyance? No abeyance. Liberty to approach if after.
That will be helpful.
Mr. Bhomik, you know the ingredients for filing an for passing an order under section 151 for implementation of police help is very strict.
My lord,
You have seen the judgment of Justice Dipankar Datta.
my lord, I have already.
So mechanically, in this way, these orders cannot be
Then-
passed.
If we get a liberty, we can approach for the on the strength of that order. I will approach.
The petitioner has prayed for implementation of an ad interim order of injunction through police help. First up, the civil suit is pending. First up. Therefore, the petitioner has to work out his remedies for implementation of such an order in accordance with the provisions of the Civil Procedure Code. First up, WPA number such and such is disposed of by giving liberty to the petitioner to approach the civil court for appropriate reliefs in accordance with law. Next.
58.
Contempt application. Lordships, I have the instruction, no amount received by my.
Yes, where is Mr.
Even if your lordships,
Who appeared?
Pritam Das and
Where is Mr. Pritam Das?
AGP.
Yes, Mr. Shah. No, not Pritam Das. Mr. Rahman and Mr. Shah appeared. Yes, Mr. Shah. He says no amount has not been
Yes.
paid.
Lordship,
That contempt application yesterday's matter.
Lordship order passed 1.5 years ago.
No, this
PPO.
revised PPO has been issued.
Issued, but your lordship,
No payment has been made.
lordship, without receive the payment, it is difficult. Your amount deducted from the gratuity is disbursed or not. Some others are the rest amount from the area and current pension amount. Your lordships. Lordship, it is noted, your lordship, order passed 1.5 years ago, your lordships. We have communicated several times. Now, as and when your lordship sitting in the circuit bench in January, that's why the PPO was issued in 27 December 2023.
Yes, Mr. Shah. Yes, Mr. Singhania has a point to make.
One.
Because it was issued only on 27th of December 2023.
After it is the intimated the department, the lordship sit in the circuit bench, the issue the willfully disobeying your lordships.
It has been disbursed. Show it to Mr. Singhania. Show it to
Because I shall be then in a position that I am not cooperating with the court property. This was my message yesterday. On this basis, I
PPO issued 27 December.
And this is the DI primary Jalpaiguri. Yesterday morning, I received this.
Mr. Shah, kindly take instructions.
Yes.
Kindly take instructions and come back, because his specific instruction is that because already he has delayed 27th of December and this order was passed on.
1.5 years ago, your lordships, and we have
So there is a delay. I can haul him up in contempt.
Yes,
for not complying with the order within the time.
Yes, sir, lordship. This is my
Specific
submission.
instructions.
This is my submission.
So 3:15. Take specific instructions and come. এখন record করবেন না? Kindly inform the officer that he has said that it has not been disbursed. Ask him to furnish you the particulars showing that it has been disbursed.
Yes. And what
he
amount?
says we did not do particulars, how much amount,
yes,
which account, when.
This is the communication.
No, not communication. Ask him to send. Otherwise, I will ask him to appear personally tomorrow.
Lordship.
That will be better, madam.
Ask him,
but one of
or
the container
we ask to appear personally tomorrow.
Madam, that will be better.
Inform me if he does not give you information at 3:15. I will ask him to appear personally tomorrow, and from here he will not be going to his home. Tell him that. From here he will not go to the home, his home. He will go somewhere else. On the face of it is his content. 1.5 years back, and only 27th of December, looking into the schedule of the circuit bench, this order has been issued. Tell him, inform me at 3:15. Otherwise, he shall personally appear tomorrow at 10:30.
Item number 60, application for bail.
Lordship, item number 60, I am praying for next circuit, your lordship.
As preferred by the learned advocate for the petitioner, list this matter before the next circuit bench.
61. 61.
Same order.
Grateful, your lordship.
Item number 87. Item number 87.
Yes.
My lord, I am for the petitioner. Led by Mr. Partho Sarathi Das. Yeah.
Yes, he is ready and willing to deposit 1 lakh.
Yes, my lord.
Yes, you are appearing.
My lord, led by Mr. Parthasarathi Das, he is on virtual mode.
Yes. Here.
Parthasarathi.
But I am for the state in criminal side.
Yes, you are appearing for the state.
Yes.
So what do you say to this? A
Actually,
copy has been served.
My lord, this is on admission state, my lord.
Oh.
Motion stage.
Yeah.
Let the copy be served, my lord.
He says this is under NI Act.
Yes, my lord.
Kindly give him a copy. Do you have your copy? Kindly share your copy with.
Sir, active, sir.
But state is not a party here.
Yes, my lord.
State is not a party.
No.
Why?
Join, sir.
It has to be made a party.
Why would not include a state as a party?
They're agreed from the order, so it has to be made a party. No, so it has to be heard.
Yes.
All right. Pursuant to no. How soon can you deposit this amount?
My lord, may I make a call to make a contact with Mr. Parthasarathi Das?
Yes. So you have to do it by Monday. If
My
that,
interim relief is really
if you do it within Monday,
5 minutes. Give me 5
Yes.
minutes. Only 5 minutes.
Passover. Yes.
Revision 60-50 guys.
Only the bail, these two items were fixed.
So my lord will be hearing the criminal revision matters today.
Difficult
Difficult.
because the other matters, some matters, orders have been fixed.
My lord.
Item number 3 and 4.
অন্যগুলো রিলিজ করে দিন আদার ম্যাটার না হলে
Other matter release except 26, 87 and 58. Other matters released for the day.
Yes, it has been passed over. Other matters have been released.
Six, except 6, 58 and 87. Other matter will remain listed in the list.
It will remain in the list, but will not be called on other day. This writ petition. Since identical questions of law and fact are involved in these writ petitions, comma, the same are taken up for analogous hearing and are decided by this order. First up. In the order of the block development officer, the order of the block development officer, Matigara Development Block, is under challenge in WPA 568 of 2021. Full stop. The The permission for construction granted by the Pradhan Matigara 1 Gram Panchayat in favor of the permission granted by the Pradhan Matigara 1 Gram Panchayat on 26th February 2020. 2020 or 2022? 2020 in favor of the private respondent is under challenge in WPA 1725 of 2021, and the petitioner has prayed for cancellation of such permission. First of all, a civil suit filed by whom? Your client.
Petitioner, yes, petitioner.
A civil suit filed by the petitioner herein praying for declaration of his right, title and interest. You can take your seat, both if you take your seat. Interest in respect of the property in question a civil suit filed
by the petitioner held, praying for declaration of his rights, title, and interest in respect of property in question.
The private respondent hearing is pending before the civil court. First, alleging that the private respondents have encroached upon the PWD road and were making construction thereupon, the petitioner hearing filed a writ petition being WPA 278 of 2020, which was disposed of by an order dated 24th of February 2020. Pursuant to the said order, the block development officer passed the order dated 19th of June 2020 wherein it was passed an order dated such and such. By observing that the construction is on private within bracket Rayati land owned by Sri Naresh Chandra Burman, and not on PWD or any government land. First. In the meantime, the Pradhan of the concerned Gram Panchayat, the Pradhan of Matigara 1 Gram Panchayat granted permission for construction in favor of the private respondent pursuant to কি বললাম in favor of the private respondent on বলেছি on 26th of February 2020 for construction of temporary tin shaded structure along with a scientific toilet. Full stop. কি উনি নেবেন নাকি? উনি নেবেন কি? আপনি নেবেন? ঠিক আছে, চলে যান তাহলে আপনি। হ্যাঁ, full stop. The Mr. Bose, Mr. Shoptanshu Basu, learned senior counsel representing the petitioner submits that the block development officer did not arrive at a specific finding as to whether the private respondent had made illegal construction on the land in question, though such authority by an order dated February 24, 2020, passed in WPA 278 of 2020, was directed to do so. First up. He further submits that the he further submits that the Pradhan of the concerned Gram Panchayat without following the procedures prescribed under the West Bengal Panchayat within bracket Gram Panchayat Administration bracket closed rules 2004 accorded permission to accorded permission for construction in favor of the private respondent. In support of such contention, Mr. Basu placed reliance upon Rule 17, 18, and 19 of the 2004 rules. He therefore submits that the permission granted by the Pradhan on the permission for construction granted by the Pradhan on 26th of February 2020 should be set aside, should be cancelled. And should be cancelled, full stop. Paragraph. Mr. Basu places reliance upon a decision. You have submitted that
Yes.
copy.
Another copy.
No, not another copy. What I will do with so many copies?
Apply.
No, this is not the complete copy. কোথায় গেল? দিলেন আপনি। না দিয়েছেন, সেটা কোথায়? Yes. Which paragraph Mr. Basu relied upon? Acha. Reliance upon a decision of a division bench of this court in the case of Prafullo Kumar Ghosh versus State, reported at 2013 2 CHN 171 কি বলে শুরু করলাম?
Mr. Basu places reliance upon a decision of a division bench of this court in the case of
In support of his contention that the procedures laid down in Rule 2004 has not been followed. Full stop. Paragraph. Mr. Mukherjee, Lanet Senior Counsel representing the private respondents, submits that the private respondents filed an application before the concerned Panchayat authority for construction of a temporary tin shaded structure on 10th of January 2020 and upon compliance of necessary formalities and the Pradhan granted permission in favor of the private respondent upon being satisfied that the private respondent is now upon being satisfied that the private respondent has complied with all formalities in that regard. He further submits that the block development officer is not authorized under the West Bengal Panchayat Act 1973 to decide as to whether the construction made on a private land was an unauthorized one or not. First of all. He further submits that since the permission has already been granted by the Pradhan in favor of the private respondent, the construction made by the private respondent cannot be said to be an illegal and unauthorized one. Mr. Mukherjee distinguished the decision in the case of Prafullo Kumar Ghosh by submitting that such decision was on the interpretation of Rule 30 and therefore the same do not have any manner of application to the case on hand. Full stop. Heard the learned advocates for the parties and produce the materials, please. It appears from the letter dated 17th of February 2022 issued by the private respondent, which Naresh is which
8. Private respondent number 8.
is issued by he's the only private respondent, issued by the private respondent, an address to the Pradhan, Matigara 1 Gram Panchayat, that an application for construction of a temporary tin shaded structure was submitted on 10th of January 2020. First up. The private respondent in the said letter has admitted that the permission was not granted by the Panchayat authority as he had not kept any provision for toilet in his site plan and application. Full stop. By the letter dated 17th of February 2020, the private respondent declared that he shall construct a specific toilet along with the tin shaded structure, and on the basis of such declaration, permission for construction of temporary tin shaded structure in the land in question along with a scientific toilet appears to have been granted by the Pradhan on February 26, 2020. February 2020, 2022 বলেছি আচ্ছা It further appears from the record that when WPA 278 of 2020 was taken up for hearing on 24th of February 2020, the submission was made by the learned advocate for the private respondent that as per convention, the private respondents have made construction in the land in question after obtaining oral permission from the Pradhan of the Gram Panchayat. Therefore, it appears that the construction, therefore it is evident that as on 24th of February 2020, construction has already been made by the private respondent. Full stop. Taking note of the submission of the learned advocate for the private respondent that construction was made after obtaining oral permission from the Pradhan of the Gram Panchayat, a coordinate bench passed the order dated 24th of February 2020 by directing the block development officer to decide by directing the block development officer to consider the representation of the petitioner and take a decision with regard to illegal construction and make specific finding on the basis of available records. After going through the order dated 19th of June after going through the order of the block development officer dated 19th of June 2020, this court finds that the block development officer has observed that a construction shed owned by Sri Naresh Chandra Bormon, that is the private respondent herein, exists with pakka wall and tin sheet and rolling shutters occupying 0.049 acres of land in LR plot number 6, only 6.
Yes, yes.
LR plot number 6 of Mauja, Thiknikata under jail number 74. The block development officer further observed that 0.10 acres of land is not lying over PWD land. Full stop. The block development officer, however, have not returned any finding as to whether the construction which was existing on the said plot, being LR plot number 6, which is the subject matter of the writ petition, was an illegal construction or not. Normally, under such circumstances, under such circumstances, the courts, under such circumstances, the matter should normally be remitted to such authority for deciding the issue strictly in terms of the direction passed in WPA, strictly in terms of the directions passed by the court. However, in the case on hand, no useful purpose will be served by relegating the matter to the block development officer as for the reasons as stated hereinafter. Immediately after the order was passed in WPA 278 of 2020 on 24th of February 2020, permission appears, Pradhan of the concerned Gram Panchayat accorded permission in favor of the private respondent. Full stop. Such permission for construction was accorded by the Pradhan on 26th of February 2020 by making an endorsement on the copy of the letter dated 17th of February 2020. The it appears that permission for construction was granted for temporary tin shaded structure. However, it appears that however, it is evident from the order of the block development officer who upon inquiry found that the construction exists with pakka wall and tin sheet and rolling shutters. Full stop. Section 23 of the West Bengal Panchayat Act states that the subsection 2 of section 23 of the 1973 Act states that every person seeking permission for erecting new structure shall make an application in writing to the Gram Panchayat. Full stop. Section 23(1) states that the Gram Panchayat shall accord such permission. Full stop. From the endorsement made by the Pradhan on 26th of February 2020, granting permission to the private respondent to construct temporary tin shaded structure along with a scientific toilet appears to have been granted by the Pradhan and not the Gram Panchayat. Full stop. Mr. Mukherjee would contend that it is for the Panchayat authority to satisfy this court as to whether the permission was granted by the Gram Panchayat and the same was communicated by the Panchayat by way of making an endorsement dated 26th of February 2020. However, the Panchayat authority is not represented and therefore such issue, however, the Panchayat authority is not represented. First of all, be that as it may, the issue Now, be that as it may, the larger issue is whether the permission can be granted. The larger issue would be whether permission for construction can be granted after the construction has been made. Full stop. Paragraph. Section 23(1) of the 1973 Act states that no person shall erect any new structure or new building or make any building or make any addition to any structure or building having plinth area of not more than 150 square meters and height not more than 6.5 meters in any area within the jurisdiction of a Gram Panchayat except with previous permission in writing from the Gram Panchayat. ঠিক আছে? Except with the previous permission in writing from the Gram Panchayat টা underline করবেন বলে ব্র্যাকেটে full stop. Upon thus it is evident that no construction can be made except with the previous permission. Therefore, a person intending to erect any new structure or new building or make any addition to any structure or building has to first obtain permission from the Gram Panchayat and thereafter raise construction thereupon. Full stop. It is it appears from the letter dated. Now it appears now. It is evident from the letter dated 10th of January 2020 issued by the private respondent and addressed to the Pradhan of Matigara 1 Gram Panchayat that the petitioner, that the private respondent had started construction of a temporary tin shaded structure measuring 5 decimals within the 10 decimals of the LR plot number 6. Therefore, it is not in this, therefore, it is an admitted fact. Now, therefore, it has been admitted by the private respondent that he has made construction prior to obtaining permission prior to even applying for permission for construction, as the application for permission claims to have been submitted by the private respondent only on 10th of January 2020. Full stop. It is well settled that a statutory authority has to act within the 4 corners of a statute. First up, Mr. Mukherjee, in course of his argument, could not satisfy this court that the Pradhan has the authority to grant post facto, has the permission to grant post facto, has the authority to grant post facto approval of a construction. First up, the Panchayat Act 19, no provision empowering the Panchayat authority to regularize an illegal construction. This court is therefore of the considered view that the construction raised by the private respondent is an illegal one, as the same was made prior to obtaining permission from the Gram Panchayat. First up, no provision under the 1973 Act has been placed by Mr. Mukherjee in support of his contention, has been placed by Mr. Mukherjee to show that the Pradhan has the power to regularize a construction which has been done prior to issuance of, prior to grant of such permission. First up, in view thereof, this court, this court holds that the permission granted by the Pradhan on February 26, 2020 is liable to be set aside and cancelled. First up, and accordingly, the same is set aside and cancelled. First up, subsection 6 of section 23, casts an obligation upon the Panchayat authority to take steps against in the event any new structure or new building or any addition to any structure or building is being or has been erected or made in contravention of provisions of subsection 1. First up, this court therefore directs the Matigara 1 Gram Panchayat to take steps in terms of subsection 6 of section 23 and to take steps, to initiate a proceeding in terms of subsection 6 of section 23 and to conclude such proceeding in accordance with law upon giving an opportunity of hearing to the petitioner and the private respondents. Full stop. The writ petitions accordingly stand allowed. There shall be, however, no order as to costs.
Time bound में kind.
কি বললাম to conclude such proceedings? A period of 4 weeks from the receipt of a server copy of this order. Full stop. With the above directions, the writ petitions allowed. আচ্ছা শুধু একটা জিনিস, the decision in the case of Prafullo Kumar Ghosh Supra is of no assistance as the same deals with deemed sanction.
Like the amount taken for the purpose of the land,
That
ought to be refunded back to us.
to be refunded to the applicant, let him pay. I don't think he will ask for refund. Then he will be.
Lordship, may I be apologized not to appear at the time of call, item number 87, Lordship.
Yes, yes,
Item number 80.
tomorrow.
I don't know 6.
All right, tomorrow. Yes, content, Mr. Shah, where is Mr. You have taken instructions. Yes, has it been released?
What has come up is that there was a miscommunication. It was already forwarded to the treasury officer. The amount is yet to be credited to the bank account because for that purpose, the
When it will be credited?
by tomorrow it will be credited.
By tomorrow. So I'm keeping it tomorrow. ekdam protome rekhe din. Ensure that it is credited. Mr. Singhania, ask your client.
Lordship, what about will be credited, Lordship, then I'll calculate the.
Do you have, Mr. Rahman?
I have.
Do you have a calculation?
Yes, ma'am.
Give it to Mr. Singhania.
Not initial. Malan, Mr. Mishra is under some difficulty tomorrow. Malan, I'm only praying for relaxation.
Yes. Yes, you are agreeable to
मैंने
that.
copy रखा है calculator में.
Pertains to negotiable instrument, yeah.
Yes.
But the order against which this modification application has been filed, my lord. There was a direction for payment of 7 lakh.
Yes.
So the private respondent presence is not very much in this place. He has been served, my lord.
My lord, I am on behalf of the respondent number 1, my lord.
He has been
You
served.
are for the private respondent?
Yes, my lord.
Yes, what do you say? You are here tomorrow, come tomorrow. Private respondent is here. So you need present because the private respondent is the
But the
effect.
state has been served, my lord.
All right. So not be here.
No, man.
Interest of your friends to appear. So I will record that.
Item number 2930. My lord, the petitioner, my lord, the retired 2018. You'll also kindly take up tomorrow, my lord.